Good morning. We're in the record. Good morning. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, and in accordance with DC Code Section 2571(h) of the Open Meetings Act (OMA), I am welcoming you to the regular scheduled meeting of the Alcoholic Beverage and Cannabis Board. This meeting has been conducted pursuant to guidance made available by the District of Columbia's Office of Open Government regarding electronic meetings held by public bodies. Electronic meetings by the ABC Board are authorized pursuant to Section 2577A of the DC Code. Pursuant to the OMA requirements, notice of today's meeting was provided 48 hours in advance of the meeting on ABCA's website and on the District Central meeting calendar. The notice includes the time, date, agenda, and call-in or login information for public participation. This electronic meeting has been hosted by a WebEx account provided by the District of Columbia government. Please address any questions or complaints to the OOG at opengovoffice@dc.gov. My name is Donovan Anderson. I'm chairperson of the board. I would like to introduce the other members of the ABC board who are also participating electronically. Please respond when I announce your names. Mr. James Short.
Mr. James Short, present.
Mr. Silas Grant.
Mr. Silas Grant, present.
The board has 3 members in attendance for the conduct of business today, and that constitutes a quorum. Before we get underway with today's hearing calendar, I need to make a few instructions very clear so that the conduct of these hearings is understood by everyone. There are 8 cases on this morning's calendar. Once your case is called, I will take a moment for IT specialists to elevate the rights for each party to enable their camera and microphone. Then and only then will you have the ability to enable your equipment. If your case is not being heard, you will remain mute and your camera will be disabled. At the conclusion of each case, the parties will have the option to leave. If the parties chooses to stay, all cameras and microphones for the concluded case will be disabled. Should you have any questions or require technical assistance during the hearing, please submit them using the question and answer feature. Our first case this morning, it's a protest hearing status, case number 24 PRO 00022, Gray's Market, license number 120092. This case has been rescheduled to April 24th at 10:30 a.m. at the request of the parties. The next case in our calendar is case number 24 PRO 00010, Up and Smoke 4 LLC, license number 126975. This case has been canceled. The board approved a settlement agreement, see board order number 2024-096. The next case in our calendar is case number 24 PRO 00008, Up and Smoke 2, license number 126850. Good morning, Mr. Oriana. Can you please elevate the rights of the ANC and the licensee in this case, please?
Sure thing. Good morning. ANC Commissioner David Sobelson, your access has been elevated. Sander Jayaraman, your access has been elevated. And Zach Lerman, your access has been elevated. That is all, Chairman.
Thank you. Mr. Lerman, do you have a camera you can turn on?
Can you hear me, sir? I'm sorry. I'm having some trouble connecting. I'm calling in.
Okay, I can now hear you. All right. Good morning, everyone. Let's start with, let me have the parties identify themselves for the record by spelling and stating their name. Let's start with you, Mr. Lerman.
Hey there. Sorry about the camera situation. I am trying to turn that on, but my name is Zach Learman on behalf of Up in Smoke 2.
Spell your name for the record, please, sir.
Yes, sir. Z-A-C-K, last name Learman, L-E-A-R-M-A-N.
Good morning.
Good morning.
All right. Mr. J. Raman, can you please spell and state your name for the record?
Sure. My name is Chandra Jaraman. I am the chair of the ABCA's Alcohol Beverage and Cannabis Committee. First
Your
name is spelled C-H-A-M-D. Last name Jayaraman.
it appears that you're moving, so your connection is poor. Just want to let you know that, sir. All right.
Thank you. My
Mr.
apologies.
Mr. Sobel's son, can you please spell and state your name for the record?
My name is David Sobelson. I'm the ANC commissioner for the single member district that includes the applicant's proposed site. My name is spelled D-A-V-I-D, that's David. Sobelson is S as in Sam, O, B as in boy, E-L, S as in Sam, O, H, N as in Nancy, S-O-B-E-L-S-O-H-N.
Good morning, sir. Good morning.
morning.
Welcome. All right, Mr. Lerman, I can see you. I just want to let you know that I can see you, sir. Are there any preliminary matters, meaning that, are there any preliminary matters that you need to make the board aware of? You're on mute, sir.
Mr. Chair, I have a
Sorry
question.
about that.
Sir.
Yeah, none on my end. I can give you a brief overview, if you like, of where we are. If that would be helpful, I think it would. We had reached a settlement agreement. The ANC 6B had voted to approve the terms. We then submitted the settlement agreement for review to ABCA Legal. ABCA Legal had some issues with some of the provisions. And right now, I believe 6B is coming up with some alternative provisions that work. And I'm amenable to, you know, what we previously agreed to. I'm amenable to the ABCA Legal's proposed changes, which I don't think 6B is, but from my perspective, we're on the same page and we're coming to a accord. It's just a matter of getting some alternate wording down.
Yes, I agree with Mr. Lehrman. I think it's just a matter of time.
All right. Well, thanks for the presentation. As you know, settlement agreements are provided to the agency and for the board for approval. And from a legal perspective, if there are provisions in an agreement that we believe are unenforceable, that's one of the reasons why legal will inform the parties that because those are unenforceable, they cannot be in a settlement agreement. I don't know what the concerns are. I'm just saying generally, those are types. So if it's brought back to the parties to say that certain provisions needs to be removed from a settlement, it is not because we do not agree with the provision. It is because from a legal perspective, the agency has determined that it is unenforceable. Okay, so I just want to give you just a that's the perspective of the agency. So whenever a settlement agreement is brought to the board, because legal has reviewed it, and legal has said to us that all of the provisions can be enforced. They are enforceable, and once they believe that it's that all the provisions in an agreement are legally enforceable, then the board will be asked to vote to approve or disapprove with the settlement agreement. Mr. J. Raman, I see you have your hand up, sir.
Yes, thank you very much. One of the things we are struggling with is
I can hardly hear you, sir. I can hardly. Maybe turn your video off, and maybe I can hear you better.
let me see. Better now?
Not really. I think it's because you're moving. So, but I that's why I'm saying if you turn your video off, maybe I'll be able to hear you better because I cannot hear you. No, sir. I can't hear you.
No.
No, I can't hear you. I cannot hear you, sir.
You all hear me now?
Yes, I can hear you better. Yes. You, Mr. Jerome, I can't hear you now. No. I cannot hear anything you're saying, sir. All right. I think that our IT person says that if you want to call in, maybe you can. If you want to call in, I'll wait. I'll wait a minute for you to call in. If you want to do that, sir. Are you going to call in? No? All right, fine. Okay, thank you. All right. It appears that this matter will be settled since the parties have provided a settlement agreement to the agency, and it's undergoing legal review. But if this matter is not settled, then we'll have a protest hearing on April 3rd at 1:30 p.m. And the only thing I just want to remind the parties, if this matter actually goes to a hearing, you have to do the PIP and 7 days. Oh, I will answer that question in a minute. And 7 days prior to the hearing, you have to do the PIP. If the parties truly, and I think in this case, because a settlement agreement was provided to the agency and it's under legal review, the parties can jointly file a motion to continue this hearing, because the hearing is scheduled for April 3rd. So the parties can jointly file a motion to the agency, to the board, to ask to continue the hearing, and we will continue it because as was presented today, a settlement agreement was provided to the agency and it's under legal review. So just send something in writing and the board will grant the extension, the postponement of the hearing, so the parties can continue discussing settlement. Okay.
What's
Any
the
other questions?
deadline?
Just you can do it. You can do it at any point. I will also alert our agency. I'll alert the agency, and legal is on top of it because, as I stated before, this matter is scheduled for a hearing on the 3rd, and a settlement agreement was provided to the agency, and it's under legal review. I believe that there should be no problem with the board agreeing to postpone the hearing so the parties can finalize the points with legal prior to the board approving the agreement. Okay.
Thank you.
All right. Thank you. All right. So good. Mr. Lehrman, did you have something to say, sir?
Thank you, sir. I was just going to say I can draft the continuance and run it by the commissioners to review before I'm just telling them, like, logistically, I can draft it and have you guys take a look at it, and then I'll send it to.
Yeah, that's fine. Thank you.
Okay.
All right. All right. Thank you. Have a great day then. All right then. Bye-bye. All right. The next case in our calendar is, we now move to our show cause hearing status calendar. It's case number 22 CMP 00086, Bujo's Restaurant, license number 1155711. Mr. Oriana, can you please elevate the rights of the government and the licensee in this case?
Sure thing. Christopher Salcott, your access has been elevated. And I believe that is all, Chairman.
All right, thank you.
Morning, Mr. Chair.
Good morning. Good morning, sir. Can you please identify yourself for the record by spelling and stating your name?
Good morning. This is Assistant Attorney General Chris Southcott, first name Chris, last name Southcott from DC's Office of the Attorney General, representing the district.
Good morning, sir. I see that the licensee is not here today, but for a show cause hearing status, the licensee is not required to be here. This matter then is scheduled for a show cause hearing on April 10th at 10:30 a.m. Just want to remind the government that 7 days prior to the hearing, the parties are required to exchange documents and witnesses that will be relied upon at the hearing. Failure by either party to comply with this provision, unless good cause is showed, the board is empowered to prevent that side from moving forward. Okay? All right. Thank you, sir, for
Thank you.
yeah. All right. The next case in our calendar is case number 23, CIT 00630, Grazie, license number 118962. Mr. Oriana, can you please elevate Mr. Cameron Mixon?
Sure thing. Cameron Mixon, your access has been elevated. That is all, Chairman.
Thank you. Good morning, Mr. Southcott. Can you please identify yourself for the record?
Good morning. This is Chris Southcott, first name Chris, last name Southcott. I'm an Assistant Attorney General with GC's Office of the Attorney General, representing the district.
Good morning, sir. Good morning, Mr. Mixon. Can you please identify yourself for the record?
Good morning, Chair Anderson. This is Cameron Mixon with the Veritas Law Firm, counsel to the licensee at CAMERON MIXON.
Thank you. Good morning again. Mr. Southcott, are there any preliminary matters in this case?
Nothing from the government.
Thank you. Any on your part, Mr. Mixon?
None from the licensee.
All right. This matter then is scheduled for a show cause hearing on April 24th at 1:30 p.m. Just again, want to remind the parties that 7 days prior to the hearing, the parties are required to exchange documents and witnesses. Failure by either side to exchange documents and witnesses 7 days prior to the hearing, the board is empowered to prevent that side from relying on documents and witnesses that have not been previously disclosed unless good cause is shown. Any questions?
Nothing from the government.
All right, thank you. Have a great day. All right. The next case in our calendar is case number 23, CMP 00097, Hill Prince, license number 104782. Mr. Oriana, can you please elevate the licensee in this case?
Sure thing. Matt Menora, your access has been elevated. That is all, Chairman.
Thank you.
Good morning, Mr. Chair.
Good morning, Mr. Menora. Mr. Southcott, I apologize, sir. Can you identify yourself for the record?
This is Assistant Attorney General Chris Southcott, first name Chris, last name Southcott, from DC's Office of the Attorney General, representing the district.
Good morning, sir. Mr. Menora, can you please identify yourself for the record?
Sure. My name is Matthew Menora from the law firm of Malleus O'Brien and Sandground, and we're ABC licensed counsel for the licensee. My name is spelled Matthew, Matthew, and Menora, Minora.
Good morning again, sir. Mr. Southcott, are there any preliminary matters in this case?
Nothing from the government.
Mr. Menora, from your perspective?
We actually just received an offer in compromise this morning that I have to show to the licensee for review, but I think we'll be able to have this wrapped up.
All right, thank you, sir. All right, then this matter is scheduled for a show cause hearing on May 1st at 10:30 a.m. If this matter goes to a hearing, the parties are required to exchange documents and witnesses 7 days prior to the hearing. Failure by either side to comply with this provision, unless good cause is shown, the board is empowered to prevent that side from moving forward. Any questions?
Nothing from the government.
All right. Thank you. Have a great day.
Thank you.
Thank you.
All right. The next case in our calendar is case number 23 CIT 00544, the Washington Hilton, license number 102-985. This case has been canceled due to the dismissal of the case by the Office of the Attorney General. The fine has been paid. The next case in our calendar is case number 23 CMP 00024, DC Shenanigans, license number 88119. This case has been canceled. An offer and compromise has been provided to the board for its review and approval. We are now at the end of our morning calendar, and since we're at the end of our morning calendar, let us now do our agenda items for the day. The first agenda item, the first agenda that we will review this morning is our legal agenda. And the first matter on our legal agenda is a review of an offer in compromise in lieu of a hearing dated March 13th, 2024 for case number 23 CMP 00024, DC Shenanigans, license number 088119. The offer in compromise is as follows. Charge 1, substantial change in operation by exceeding approved occupancy limit. This is a fourth primary tier violation. Statutory authority, DC Code Section 25726B1. The fine, there is a fine of $30,000 to be paid by May 1st, 2024, or the license shall be suspended indefinitely until the fine is paid. The license will also be suspended for 30 consecutive days to be served April 23rd, 2024 to March 21st, 2024. Charge 2, violated terms of approved security plan. This is the fourth primary tier violation. Statutory authority, DC Code Section 25823A6. This charge has been dismissed. I therefore make a motion that the offer in compromise be accepted. Is there a second?
Short, I second.
Mr. Short has seconded the motion. We'll now have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 2, review of applicant's motion to strike protestants exhibit and witness list dated March 14th, 2024 in case number 23 PRO 00096, DC Food Market, license number 106962. I make a motion that we deny this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 3, review of protestants' opposition to applicant's motion to strike protest exhibit and witness list dated March 15th, 2024 in case number 23 PRO 00096, DC Food Market, license number 106962. This is now moot. Number 4, review of applicant's motion to strike protestants exhibit and witness list dated March 14th, 2024 in case number 23 PRO 00097, King Convenience Store, license number 089932. I make a motion that we deny this request. Is there a second?
Short, I second.
Mr. Short has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 5, review of protestants' opposition to applicant's motion to strike protestants exhibit and witness list dated March 15th, 2024 in case number 23 PRO 00097, King Convenience Store, license number 089932. This is now moot. Number 6, review of respondents' contested motion to continue show cause hearing in case number 2023-25 1-00016. This is Madam's Organ, license number 025273. I make a motion that we deny this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant. Mr. Grant.
I said, Mr. Grant, I agree.
I apologize, sir. Mr. Anderson, I agree. The matter passed 3-0. Number 7, review of the government's opposition to respondents' contested motion to continue show cause hearing in case number 2023-251-00016. Madam's Organ, license number 025273. This is now moot. We have now disposed of our legal agenda, so let's now do our licensing agenda. The first matter on our licensing agenda, I'm sorry. The first matter on our licensing agenda, it's review a request to remove the license from safekeeping to reopen on March 26, 2024. This is for Nicolata Italian Kitchen / Cucina Marina, license number 110211. I make a motion that we approve this request. Is there a second?
Short, I second.
Mr. Short, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 2, review application to extend safekeeping of license. This is for Kintaro, license number 092986. I make a motion to approve this request through September 30th, 2024. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 3, review request to extend safekeeping a license. This is for iBar / Garden of Eden, license number 083133. I make a motion that we approve this request through September 30th, 2024. Is there a second?
Short, I agree.
Mr. Short.
I second.
Mr. Short has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 4, review request to extend safekeeping a license. This is Skylark. The establishment is formerly Skylark Lounge, license number 090611. I make a motion to approve this request through September 30th, 2024. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant, I second the motion. We'll now have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 5, review request to extend safekeeping a license. The Roberts Law Group, license number 083728. I make a motion that we approve this request through September 30th, 2024. Is there a second?
Short, I second.
Mr. Short, I second the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 6. Review application for class change from retailer class D restaurant to retailer class D tavern. This is for DCJCC, license number 024489. I make a motion that we placard this matter. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 7, review application for change of hours to open earlier. This is Annie's Paramount Steakhouse, license number 007930. I make a motion that we approve this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 8, review request to expand the inside premise capacity for a total occupancy load of from 190 to 279. This is Thirst Lounge license number 126287. I make a motion that we refer this back to licensing. Is there a second?
Short, I second.
Mr. Short has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 9, review application for Sidewalk Cafe endorsement with 31 seats. This is St. Regis Hotel, license number 099454. I make a motion that we placard this matter. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 10, review request to remove the carry out and delivery endorsement. This is Meat and Friends, license number 092127. I make a motion that we approve this request. Is there a second?
Short, I second.
Mr. Short, I second the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. We now move to our supplemental licensing agenda for March 20th, 2024. There are 2 requests on the supplemental agenda, and without opposition, I make a motion that the requests on the supplemental licensing agenda be approved. Is there a second?
Short, I second.
Mr. Short, I second the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. We now move to our cancellation agenda for Wednesday, March 20th, 2024. There are 4 licenses to be canceled on the cancellation agenda for March 20th, 2024. And without opposition, I make a motion that all the applications on this agenda be approved for cancellation. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll now have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. We now move to our medical cannabis licensing agenda. And on this agenda, we're first going to do the conditional retailer and internet retailer applications. The first applicant on this agenda is review of social equity application for conditional retail license. This is Welcome, license number 127936. I make a motion that we approve this request. Is there a second?
Short, I second.
Mr. Short, I second the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 2, review of social equity application for conditional retailer license. This is for Nug Heaven, license number 127932. I make a motion that we approve this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 3, review of social equity application for conditional internet retail license. This is for Nug Heaven, license number 127935. I make a motion that we approve this request. Is there a second?
Short, I second.
Mr. Short has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 4, review of social equity application for conditional retail license. This is for Capital Butts, BUDZ LLC, trade name to be determined, license number 127929. I make a motion that we approve this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 5, review of social equity application for conditional retail license. This is the Family Tree LLC, trade name to be determined, license number 1278855. I make a motion that we approve this request. Is there a second?
Short, I
Mr. Grant.
second.
Mr. Short and Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 6, review of social equity application for conditional retail license. This is for Happy Bud, trade name to be determined, license number 1277940. I make a motion that we approve this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 7, review of social equity application for conditional retailer license. This is for the Stash DC LLC, trade name to be determined, license number 128022. I make a motion that we deny this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 8, review of social equity application for conditional retail license. This is for the Stash DC LLC, trade name to be determined, license number 128023. I make a motion that we deny this request. Is there a second?
Short, second.
Mr. Short has seconded the motion. We'll now have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. We're now on the standard retailer applications. Number 9, a review of standard application for new retailer license with delivery endorsement. This is Green Label license number 127434. I make a motion that we placard this matter. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll now have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 10, review of social equity application for a new retailer license. This is for DC Garden Hill, license number 127570. I make a motion that we deny this request. Is there a second?
Short, I
Mr. Grant.
second.
Mr. Short and Mr. Grant have seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 11, review of standard application for a new retailer license. This is for Luxury Soil LLC, license number 127172. I make a motion that we deny this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 12, review of standard application for a new retailer license. This is for Royal Tobacco DC, license number 127516. I make a motion that we deny this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 13, review of standard application for a new retailer license. This is Capital Buds LLC, license number 127907. I make a motion that we deny this request. Is there a second?
Short, I second.
Mr. Short has seconded the motion. We have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 14, review of standard application for a new retailer license. This is Havana LLC, license number 127417. I make a motion that we deny this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 15, review of social equity application for new retailer license. This is for H and Vape Smoke Shop LLC, license number 127519. I make a motion that we deny this request. Is there a second?
Short, I second.
Mr. Short and Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 16, review of standard application for new retailer license. This is for Grow Warriors Farms LLC, trade name to be determined, license number 127908. I make a motion that we deny this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 17, review of standard application for new retailer license. This is for Buddha Flies, license number 127007. I make a motion that we deny this request. Is there a second?
Short, I second.
Mr. Short has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 18, review of standard application for new retailer license. This is for High Style Juji, Jiu Jitsu, JITSU LLC, license number 127301. I make a motion that we deny this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 19, review of standard application for a new retailer license. This is for District Tobacco, license number 127313. I make a motion that we deny this request. Is there a second?
Short, I second.
Mr. Short has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 20, review of standard application for a new retailer license. This is for District Tobacco, license number 127375. I make a motion that we deny this request. Is there a second?
Short, I second.
Mr. Short and Mr. Grant have seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 21, review of standard application for a new retailer license. This is for District Tobacco, license number 127543. I make a motion that we deny this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 22, review of standard application for a new retailer license. This is for Runt House, license number 127547. I make a motion that we deny this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. These are now the standard internet retailer applications. Number 23, review of standard application for a new internet retailer license. This is for It's Just Weed DC LLC, trade name to be determined, license number 127926. I make a motion that we deny this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 24, review of standard application for a new internet retailer license. This is for Acardi Clothing, KLOTHING LLC, trade name to be determined, license number 127925. I make a motion that we deny this request. Is there a second?
Short, I second.
Mr. Short has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 25, review of standard application for a new internet retailer license. This is Money Machine LLC, license number 126872. I make a motion that we deny this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. We now move to the Standard Cultivation Center and Manufacturer Applications. Number 26, review of standard application for a new manufacturer license. This is Grow Warriors Farms LLC, trade name to be determined, license number 127910. I make a motion that we deny this request. Is there a second?
Short, I second.
Mr. Short has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. And number 27, review of standard application for new cultivation center license. This is for Maven, M-A-V-N Wellness Group, license number 127808. I make a motion that we deny this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll now have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Mr. Short.
Short, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. We now move to the board's temporary license and one-day substantial change. There are 8 applicants on this license. I will review the name of the applicants, the type of license that that's been requested, the date and the license number and the attendees. The chair will make recommendations to the board, and at the end of this, I'm asking that the ABC board members approve these applications based on the recommendations of the chair. The first applicant is a request from APASRIN. The last name is SUVANASAI. This is for one-day license class F for the National Building Museum. This is on March 28th. The license number is 127941, 70 attendees, 2 security guards. Number 2, our request from Michelle Gleaton, a one-day license class F. A holiday party for the Lillian and Albert Small Capital Jewish Museum. The event is March 24th. The license number is 127921, 100 attendees, 4 security guards. Number 3, another request from Michelle Gleaton, a one-day license class F. Guardian class, April 3rd. The license number is 127922, 30 attendees, 4 security guards. Number 4, a request from Homer Twig, TWIGG, a one-day license class G, the 25th anniversary luncheon. This is on April 21st. The license number is 127973, 200 attendees, 4 security guards. Number 5, a request from Wen-Cooney, K-U-N-I, the last name is C-E-A-N-T, one-day license class G, Talent Expo, April 13th. The license number is 128010, 250 attendees, 5 security guards. Number 6, a request from CH Management Corp. It's for pub crawl, the Margarita March, May the 11th. The license number is 105025. The substantial change number license is 24 PCE 00009. This is we're recommending that we conditionally approve 1,000 participants. Number 7, it's a retroactive event. This event was a request from Joel Buckner, a one-day license class F for the Dream Collective. The date of the event was March 16th. The license number is 127970. This was 75 folks attended, and there were 2 security guards. Number 8 was a request from Steve Billadas, a one-day license class G. Axios News Media. This is March 18th through the 19th. The license number is 127946, 225 attendees, 5 security guards. I therefore make a motion that the board approves the one-day license substantial change docket and the licensees and the recommendations as requested by the chair. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short,
Short, I agree.
Mr. Grant,
Mr. Grant, I agree.
and Mr. Anderson, I agree. The matter passed 3-0. The next application we have is a licensed administrative docket streetery. I make a motion that this docket from the licensed administrative docket streetery for Wednesday, March 20th, 2024, be approved without objection. Is there a second?
Short, I second.
Mr. Short has seconded the motion. We'll have a roll call vote. Mr. Short,
Short, I agree.
Mr. Grant,
Mr. Grant, I agree.
and Mr. Anderson, I agree. The matter passed 3-0. We now move to our final agenda item for today, which is the license administrative docket. And this docket, there are 25 applicants on this docket. And so therefore, without objection, I make a motion that all the applications on the license administrative docket for March 30th, 2024 be approved without objection. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll now have a roll call vote. Mr. Short,
Short, I agree.
Mr. Grant,
Mr. Grant, I agree.
and Mr. Anderson, I agree. The matter passed 3-0. We're now at the end of our morning agenda and our morning calendar and our morning agenda items. And without any further business, the board will be in recess until our 1:30 hearing. I now request that all board members return to executive session for further action. Good morning. Thank you. Good afternoon. We're in the record. Good afternoon, everyone, and welcome to the afternoon session of the ABC Board. My name is Donovan Anderson, Chairman of the Board, Chairperson of the Board. Joining me this afternoon are Mr. James Short and Mr. Silas Grant. The Board has 3 members in attendance this afternoon, and that constitutes a quorum. We have I'm going to call the cases on our afternoon calendar out of order, and so we can quickly dispose of our calendar. The first case I'm going to call, it's a protest hearing case number 23 PRO 00090, Safeway, license number 105295. This case has been canceled due to dismissal of the protest of ANC2B. See board order number 2024-094 and board order number 2024-124. The next case in our calendar is case number 24 PRO 00004, New Smoke Shop, license number 126727. This case has been rescheduled to April 24th at 1:30 p.m. at the request of the parties. The next case in our calendar is case number 24 PRO 00006, No Kids Allowed, license number 126742. This case has been canceled due to the submission of a settlement agreement that has been accepted by the board. And so the only case that we have on our calendar this afternoon is a show cause hearing, case number 23-251, 00016, Madams Organ, license number 25273. Good afternoon, Mr. Oriana. Can you please elevate the rights of the parties in this case?
Sure. Good afternoon. Investigator Mark Ruiz, your access has been elevated. Christopher Southcott, your access has been elevated. Richard Bianco, your access has been elevated. And Sarah Reynolds, your access has been elevated. That is all, Chairman.
Good afternoon.
Good afternoon.
Let me have the attorneys, good afternoon. Let me have the attorneys identify themselves for the record, starting with the government.
Good afternoon, Chairman Anderson. This is Assistant Attorney General Chris Southcott, first name CHRIS, last name SOUTHCOTT, from DC's Office of the Attorney General, representing the district.
Good afternoon, Mr. Bianco.
Good afternoon, Mr. Chair and members of the board. Richard Bianco on behalf of the respondent in this case, 2461 Corp. RICHARD BIANCO. With me, I have the establishment's manager, Sarah Reynolds, as well as the owner, Bill Duggan, and I can have them introduce themselves separately at your pleasure.
I think we'll do that shortly. There is a preliminary matter that I would like to address at the beginning of the hearing. I am aware, Mr. Bianco, that you had filed a complaint. You had filed a motion asking for this matter to be postponed. The government had opposed your motion, and clearly we're here today. And so on our legal agenda this morning, the board denied your motion, and so therefore that's why we're here. It's my understanding that in moving forward, that you might want to call a witness out of order. We can address that if that is still relevant. Okay.
Thank you very much, Mr. Chair. I appreciate you putting that on the record. As of right now, it's not based on when we're being called. I had planned for the potential of delay, but since we're going forward on time, I think I can call him in order. If that changes, I will speak up and let the board know.
All right, thank you. Mr. Southcott, are there any other preliminary matters that we need to deal with before we move forward?
Yes, there are a couple of preliminary matters from the government with respect to the witness list that has been provided by the establishment. The first is that as iterated in the district's opposition to its continuance, The district believes that eyewitness testimony to the events that led to the altercation, which took place on May 21st, 2023, are not relevant to these proceedings. The reason for that is that the single charge that the district is bringing is that the establishment violated its security plan by failing to file an incident report, or failing to create an incident report, and failing to contact MPD or EMS following an emergency situation. As such, the particular nature and truth of whose account and whose eyewitness account holds is not relevant to these proceedings and the determination of the charge before the board.
Um, I'm sorry, as you're aware, Mr. Southcott, the government has a burden to prove its charge, and so the licensee doesn't have to put a case on because it's up to the government to prove that the infraction occur. And I don't believe that the board is in a position to tell the licensee how he can respond in defending the charge that was that we're here for today. So as I stated before, you have the burden, and so you need to convince the board that the infraction did occur, and then the licensee will respond as he sees appropriate to respond if the licensee determines that he needs to put a case on to defend its position. So I don't know if it's a motion that you're making for us to exclude.
I am making a motion to particularly to have excluded as witnesses Walter Johnson, Aaron Payton, Zach Miller, Giovanna Clark, who have all been identified as eyewitnesses under respondent's witness list.
Well, yes, Mr. Bianco, go ahead, sir.
This is so this is very unusual, as the chair mentioned. It's their burden to prove their case. When I had the discussion last week with Mr. Southcott about continuing the matter, he mentioned that he believed that there's no facts that we can put on here that would be successful in defense. And at that point, I invited him to file a dispositive motion if he thought that there were no material facts in dispute. He declined to do that. Had he done that, we would have been able to lay out in brief format exactly what facts are in dispute. But the government opted to not do that and to tell us what defense we are allowed or are not allowed to put on, we think is something inappropriate for the government to dictate. There are, in fact, facts in dispute in this case, and our witnesses are going to hash that out. If there was a motion to be made that would have disposed of this matter, it should have been made.
Mr. Chair, may I respond?
Sure, sir.
I'd like to recategorize the characterization of my comments, which were not that there were no dispositive facts, or rather that there were no set of facts that the establishment could put on that would mean that they are not liable to the charge. Rather, the facts that are relevant to the charge are whether the establishment did or did not contact MPD or EMS following an emergency situation, and whether the establishment did or did not create an incident report of this situation. Those are relevant facts, and the district is perfectly fine to hear testimony related to any dispute that arises as to whether those factual conditions have been met. But because the charge is for the establishment violating its security plan by not contacting MPD or EMS and by failing to create an incident report, the district is simply seeking to cabin irrelevant information and testimony that has nothing to do with the actual charge in this case, which is whether the establishment abided by their security plan, which has nothing to do with whose account of what actually took place on the night of May 21st, 2023 is correct. So Mr. Bianco is incorrect in saying that the district does not believe that there are any set of facts that the establishment could put on that would refute the district's case. The district just is clarifying what the scope of the case is, and that scope does not include speculative testimony about what did or did not occur. Testimony about whether an incident occurred at all is relevant, but not testimony as to what happened during that incident.
all we have a charge, we know the charge, and it's the government's burden to sustain the charge. And so at this juncture, the board is not going to take a position on your motion. I think that once the government has presented its case and the applicant decides to defend its case, they'll call witnesses, and I think that you can raise an objection, and we'll find out the nature of the testimony that we can have. Mr. Bianco can provide us a synopsis of what it is that the witness will testify to, and then we can address it at that juncture. But I think it's premature. I don't know who the witnesses are. I see there are a lot of witnesses on the list. I don't even know how many witnesses he plans to call this afternoon. And so maybe one of the things that we can start off is how many witnesses? Right. Yeah, I stand corrected, as I stated before. At the juncture that the government, that the respondent decide to call a witness, you can raise your motion, and then we can then the board will rule at that juncture if a witness is called. Okay. So just preliminarily, how many witnesses does the government have?
The government will be calling investigator Mark Ruiz as its only witness.
Thank you. And Mr. Bianco, if you decide to call witnesses, how many witnesses will you be calling?
So I can't say at this point, Mr. Chair, because our case is responsive to the government's case. So our herd of witnesses may be thinned, so to speak, depending on what information is elicited in the government's case in chief. I will, for the purpose of timing, tell the board that my intention is to call 3 witnesses.
All right, that's fine. That's fine, sir. I did briefly look at your witness list, and I think I saw maybe almost 10 people listed. I believe, and so I was just trying to get for time, just to get an idea how long this hearing might go. All right. So
the district does have a second
yes, sir.
matter related to the witness list. If the district would also be objecting to calling Joseph Massey as a potential expert witness in this matter. I don't know if he's one of the 3 that Mr. Bianco was potentially indicating that he would be calling. If so, if not, then that obviously the objection is moot.
Yes.
To the extent that he would be calling him as an expert witness, the district does not believe that he's qualified to testify in this matter.
Let us wait to see once you have rested and the respondent, if this respondent is going to call witnesses, and once the witness is called, then you'll have the right to object to the witness, and the board will make a ruling at that juncture. Okay.
Okay. Thank you,
All
Mr.
right,
Chair.
thank you. All right. Does the government wish to make an opening statement?
Yes, the government does.
Go ahead, sir.
Good afternoon, members of the board. We are here to discuss the investigation that occurred related to an incident that took place in the early morning hours of May 21st, 2023 at Madams, Oregon. In spite of the, at times, conflicting accounts that underpin this case, at heart, we have a fairly simple matter. On May 21st, a violent physical altercation occurred at the establishment between patrons Jacob Scheit and Giovanna Clark and employees Walter Johnson and Aaron Payton. Now, who is at fault for the altercation is disputed, but what is undisputed is that following the altercation, Mr. Scheit filed a police report with MPD reporting the incident. You will hear that MPD conducted an investigation into the incident, reaching out to staff at Madams, Oregon. You will also hear that the MPD report generated by Mr. Scheit triggered ABCA to conduct its own investigation into the events of May 21st, 2023. That investigation led to one charge, namely that Madams Organ failed to abide by the terms of their board-approved security plan by failing to contact the Metropolitan Police Department or create an incident log after a violent incident occurred inside the establishment in violation of DC Code Section 25-823A6. Now, crucially, failure to follow its security plan is the only charge that the district is bringing against Madams Organ, and therefore testimony about who is at fault in the altercation is irrelevant to this proceedings. It does not matter if Mr. Scheit was at fault for it, or Ms. Clark, or Mr. Payton, or Mr. Johnson. What matters is that an incident occurred, and that incident triggered obligations for Madams Organ under their security plan. So the district takes no position on whose eyewitness interpretation is correct. You will hear statements from patrons Scheit and Clark who place the blame for the altercation at the hands of the establishment's security staff. By contrast, security staff Johnson and Payton provided statements to ABCA placing the blame for the altercation at the hands of Mr. Scheit. But who is at fault has no bearing on the nature of this case. You will hear Investigator Ruiz testify that regardless of whose version of events you believe, there are consistencies which exist between the accounts. All of the accounts describe a physical altercation between a patron and Madams Organ staff. Accounts from both the patron and Madams Organ employees describe security staff making comments which escalated the situation. All accounts describe an assault taking place. And accounts from both the patrons and from security staff describe Mr. Scheit suffering physical injuries as a result of the encounter. And so regardless of whose version of events is true, you will hear Investigator Ruiz testify that according to every eyewitness account provided to him in the course of his investigation, each version of the events of May 21st triggered requirements for Madams Organ under their security plan. Now, what were those requirements? You'll hear that under their security plan, police and/or EMS are called for any emergency situation. Investigator Ruiz will testify that each account of the altercation constituted an emergency situation which required police and/or EMS to be called, and the establishment failed to do so. You will also hear that under the security plan, managers are required to make incident reports for any issue that arises inside the bar. Such incident reports exist so that in the event of an investigation, MPD or ABCA can refer to the already created incident report instead of having to rely on a statement made by employees who know that they are under investigation. Yet Investigator Ruiz will testify that he never received an incident report generated by a manager of the establishment. And to date, the establishment has failed to produce such an incident report. To the extent that the establishment has provided any account of the events of May 21st, those accounts were not recorded until June 10th, 2023, which was several weeks after the events in question, and which occurred after MPD reached out to the establishment in the course of its investigation into the altercation. Based on these facts, the district asks at the end of these proceedings, this board find Madams Organ liable for violating DC Code Section 25-823A6 by failing to follow its security plan. Thank you.
Mr. Bianco, do you wish to make an opening statement or you defer?
I will make an opening statement at this time.
Okay, go ahead, sir.
Members of the board, as you hear the evidence in this case, it is important to remember what this case is about. It's not about excessive force. It's not about misconduct by a security employee or some wrongful act of violence committed by the establishment. Nor is this case brought under the amorphous unlawful purpose provision that can mean basically anything. If we look at the charging document, what's alleged here is that the establishment failed to call MPD or make an incident log report after a violent incident occurred inside of the establishment in violation of the board-approved security plan. Our position on this is twofold. Number one, nothing alleged in the charge is a violation of the letter or the intent of the security plan as approved. Number two, the facts as they occurred, all of which were on a public sidewalk and not inside the establishment, did not trigger either of the cited provisions of the security plan. It is the government's burden to prove that the establishment's response to this occurrence violated their own security plan. By the plain language of the document and application of the facts to the agreement and the law, it is clear that no violation occurred. The government glosses over some very important facts that they must prove in order to make their case. Namely, number one, as alleged, that the incident occurred inside the establishment. It's pretty universally clear from what they've presented, it absolutely 100% did not. Number two, what counsel dances around but does not directly address is the MPD notification requirement in the security plan. If it exists, only requires notifying MPD in the case of a quote unquote emergency. Does he address specifically what constitute that? He does not. Every single skinned knee or grabbed shirt or shove does not constitute an emergency. And that's not me saying that. That's not going to be my client saying that. That is going to be the witnesses that we present and the Metropolitan Police Department's own guidance saying that. At the conclusion of the government's case, what we think we're going to see is a motion in the style of a directed verdict, where the government cannot meet its burden, has not met its burden on the charging documents alone, and the board will see fit to decide this case summarily. Thank you very much.
Thank you. All right, does the government wish to call a witness?
Yes. At this time, the government would like to call ABCA investigator Mark Ruiz.
Mr. Ruiz, can you raise your right hand, please? Do you swear or affirm to tell the truth and nothing but the truth?
Yes.
Your witness, sir.
Thank you. Investigator Ruiz, could you please briefly introduce yourself to the board?
Investigator Mark Ruiz with MARKRUIZ. I'm an investigator with the Alcoholic Beverage and Cannabis Administration, also known as ABCA, in which my primary responsibilities include investigating and inspecting alcohol license establishments throughout the District of Columbia.
And how long have you been in that position?
5 years now.
In the course of your time as an investigator, have you investigated cases involving violent altercations between bar staff and patrons?
Yes.
In the course of your investigation as an investigator, have you investigated cases that involve violations of a security plan?
Yes.
Did you conduct an investigation into Madams Organ based on events which occurred on May 21st, 2023?
Yes.
Could you describe how this case came to you?
It was assigned to me from the supervisor. It was another investigator's case, and she had to leave on emergency leave, so he asked me to take a look at it, review it, in which I did.
And in the course of your investigation, did you create a case report?
Yes.
Would you recognize that case report if you saw it?
I would.
This time, I know that the case report is already admitted into evidence, Mr. Chair, but I'm going to be largely referring to the case report having the investigator testifying off. But I'll pull it up as needed. I don't need to get there quite at this point, but I just did want to note that for the record.
So noted.
Investigator Ruiz, was there a MPD report that ABCA received which triggered this investigation?
Yes.
And now I will pull up. I'd like to, if I could, share my screen.
Mr. Orion, I can't.
Granted.
Go ahead, sir. You have access.
Is this visible to the board?
Yes, sir.
Okay. Actually going to head down a little bit. Investigator Ruiz, this is marked as Exhibit 1. Can you identify what this document is?
Yeah, this is the MPD incident report, CCN 23079946.
And this is the incident report that you received, which triggered your investigation, correct?
Yes.
Okay. Could you read the public narrative contained in the police report?
MPD received a call for an apparent assault report. Once on scene, it was determined that V1 got into a verbal altercation about his significant other with the club bouncers. V1 stated that once his significant other came from out of the restroom, he confronted the bouncers in reference to the statement that they made. V1 states that the bouncer grabbed him, which resulted in a altercation outside of the club. V1 states that other bouncers inside of the establishment came out and assaulted him as well. S1 was last seen following V1 and W1 until they were able to get to another safe location nearby.
And could you identify who V1 is?
V1 would be one of the victims, Jacob Richard Scheidt.
And could you identify who W1 is?
W1 is identified as Giovanna Clark.
And S1 is identified as who?
Unknown.
Is S1 indicated to be a member of Adams Morgan security staff?
Based on knowledge, it is indicated.
Okay. Based on your receipt of this police, actually, sorry, one more question on this. Who creates, or where does the public narrative come from in a police report like this?
This created from the police officer that responded to the victim's call.
Okay. And did MPD generate this in response to a report that was filed by Madams Organ or any of its security staff or employees?
This was generated from a 911 call from the victims.
And the victim is Jacob Scheidt, correct?
Correct.
And what's the report date and time of this?
May 21st, 2023, 5:33 a.m.
Thank you. At this time, I would like to direct your attention to what has been marked as exhibit number 2. Could you identify what this document is?
Exhibit number 2 is a statement from Jacob Scheidt regarding the assault that occurred on May 21st, 2023 at Madams Organ.
And how did you receive this statement?
This statement was provided to me by investigator Dantzler, who started the investigation and obtained them from the victims.
And how did she receive the statement?
Via email.
Who did she receive it from?
Mr. Scheidt.
Okay. I don't want to have you read every part of this document into the record, but I will have you read parts of it.
Mr. Chair, I'm going to object before there's any reading of this document into the record. My objection is twofold. One, the board has, I believe, admitted this document into evidence already, so it's unnecessarily repetitive. And number two, I would object on the basis of unreliable hearsay. While hearsay is admissible in administrative proceedings, that hearsay has to be reliable. This particular document does not meet the criteria. One, it's double hearsay. This particular witness did not take this statement by his own testimony. It was taken by someone else who then provided it to him. And number two, this particular person that it is taken from is somebody who has an interest in the outcome of these proceedings in his favor. Based on that, the self-serving statement is not something that the board should consider since it's not direct evidence or otherwise reliable?
I have several responses to that. The first response is that this statement is not duplicative. It is important to understand, based on there were very sparse accounts that of what actually occurred and whether that triggered any obligations in the establishment based on the police report. Going through the statement is necessary for Investigator Ruiz to make a determination as to whether the events as depicted therein triggered any obligation for the establishment to comply with various provisions of its security plan. Second, this isn't hearsay. It's not because it's not being admitted for the truth of the matter asserted therein. As I mentioned in my opening, the district throughout these proceedings will take no position on the veracity of any of the statements that are being made in any of the various 4 eyewitness accounts of which were provided to the investigator. The reason why these statements matter is because these statements all speak to Investigator Ruiz's investigation and what he did and his analysis as to whether any of the statements triggered an obligation to for the establishment to conduct certain provisions under its security plan. As such, it is important for the board to have the context needed for an evaluation and determination of whether, even assuming arguendo that one of these statements or any of them are credible, because the district's case will show that under each statement made, the provisions of the security plan were triggered. It does not matter the truth of what is being asserted in them. Therefore, it's not actually hearsay. Beyond that, to the extent that any of the truth or lack thereof would be admitted into this, that speaks to weight, not admissibility.
I'm going to overrule the objection, and so I'll allow the witness to testify.
Okay, Investigator Ruiz, you have reviewed this statement, correct?
Yes.
Okay, and does this statement describe an incident that occurred between a patron and members of security staff which originated inside the bar?
Yes.
Why did it originate inside the bar?
The bar was closing and the bouncers were trying to get the victim to leave the bar.
And per this statement, did a member of the establishment say anything to him as he was leaving the bar?
Objection. What we just heard counsel argue is that this document is not being offered for the truth of the matter asserted. And now he's asking the witness directly what happened in this version of the events.
It's still not being admitted for the truth of the matter asserted because the district is taking no position as to whether this is or isn't true. The district is simply saying, is trying to state that there was an incident that is consistent with every account that is provided, regardless of which account that you believe, and that regardless of whose version of events is depicted, there are consistencies which indicate that an incident occurred which triggered the security provisions of the establishment. This is crucial for the district in terms of demonstrating the only charge, which is whether an incident occurred which required provisions under the security plan.
If whether an incident occurred is dependent on the truth of the matter in this particular document, then the district doesn't meet its burden.
But Mr. Bianco, let me ask you a question. Is your client disputing whether or not the incident occurred inside, outside? Did an incident occur?
An incident occurred outside the bar on the sidewalk, and the content of any statements made inside of the bar is neither here nor there, and the only evidence presented is inadmissible hearsay.
As I stated before, and I think as stated by the government, it is not, the document is not is not submitted for the truth to say the version. I believe, I think it appears that there's no dispute that an incident occurred. Where the incident occurred, well, that's factually for the board to make a determination later on in your case to say, because I think part of the argument by the respondent is that because the incident did not occur inside the establishment, that the security plan provision were not triggered. I think that's what I heard earlier from you, the respondent. So, I mean, I'm going to overrule the objection and allow the witness to testify. I don't know what this case is about. So, in the sense that this is a first impression, so I'm just trying to figure out how the board can make a determination, and I believe that in cross-examination, you'll have an opportunity to cross-examine the witness, and if your version is correct, then you should be able to establish that on the record during cross-examination of a witness. So I'm going to overrule the objection.
Thank you, Mr. Chair. Back to my question, Investigator Ruiz. Per this account, were there statements that were made from employees to the patron?
After the demand, bouncer demanded him to leave, and after he was explaining that he was waiting for a significant other, bouncer yelled several statements at him as he was inside the establishment.
What did they yell at him?
So the bouncers rudely, I'm reading from the statement, the bouncers rudely refused and repeatedly yelled, quote unquote, "Don't worry about her. She's probably in there fucking dudes and sucking dicks," quote unquote.
After that statement was made, according to this interpretation of events, did Mr. Scheit then leave the establishment and wait for Miss Clark?
Yes.
And once they left, did Mr. Scheit and Mr. Clark then continue to have a discussion with the bouncer, which continued out onto the sidewalk?
Yeah, Mr. Scheit told Miss Clark what occurred about the insult, and I believe she confronted the bouncer about it.
So I am going to have you read from this top paragraph, starting from the sentence, "the bouncer," and continuing to the end of the paragraph. Could you please read that portion of the statement?
You're talking about first paragraph?
Yeah.
Second sentence?
So, yeah, the bouncer responded by yelling.
The bouncer responded by yelling the insult again in her face. As the first bouncer shouted this at Giovanna, as we were both standing on the sidewalk outside, another bouncer, shorter with light brown skin and dreadlocks, grabbed me with both hands from behind and attacked me. I turned into him and faced him while demanding that he release me several times. The second bouncer refused and continued assaulting me in an attempt to force me to the ground. When it was clear he would not take his hands off me, I reacted in self-defense and reversed his attempt to bring me to the pavement.
Could you also read the next paragraph?
Now, with both of us on the sidewalk, the second bouncer knocked my glasses off my face. I attempted to grab my glasses from the ground as another bouncer kicked and punched me while another deliberately stomped on my glasses. After I got clear of the altercation, Giovanna and I began walking away as another patron attempted to create space between myself and attacking employees who now numbered around 5 to 6 men. They continued to follow us down the street, mocking us and hurling additional insults.
Thank you. So, according to the statement, after that altercation ended, did Mr. Scheit eventually call emergency services?
Yes. He called 911, and they responded to the hotel he was at.
And per his statement, did he end up going to the emergency room?
I believe he received medical attention, from what I understand. And I believe from on site from an ambulance.
I'll direct your attention to the final paragraph of the statement. Does the second sentence of that paragraph indicate that Mr. Scheit received medical attention at an emergency room?
Yes.
Okay. Does his statement describe the injuries that he suffered as a result of his interpretation of what occurred?
Yes.
What injuries did he sustain?
Emotional strain.
In the top paragraph on this page.
The cuts and bruises to both arms, his forehead, torso, palms, and large lacerations to both knees. And then his glasses was also crushed.
And did those wounds, were they temporary?
His description says that they cause serious pain for weeks, and at the time have yet to fully heal.
Did you receive any images attached to this statement?
Yes. So this statement was provided to me. However, I did have email communication with Mr. Scheit afterwards, following up on his visit to the establishment. During that time, he provided me the photos of his injuries.
Would you recognize those photos?
Yes.
So, Mr. Chair, I'm going to object here, but I want to first see how you'd like to handle the objection. So the objection I'm going to make is to the photos specifically, and I think I'm going to have some testimony in order to hash out the objection. And I am glad to hold off until cross-examination, at which time I can move to strike the photos, or I'm glad to voir dire on the photos at this point, whatever the board prefers.
I think part of the this is is this a portion of the investigator's report?
Yes, this is contained in the case report.
So I'm unsure, Mr. Bianco, what would you voir dire? I mean, the investigator is just reporting based on what was provided to him. This is not, go ahead, sir.
No, I understand, but attaching inadmissible evidence to an investigative report doesn't make it admissible. So my issue here is that these photos are undated. There's no identifying information on them. There is no indication as to when they're taken. There's no indication as to who took them. And there's no one to testify that they truly and accurately depict the condition that existed at the time. These are all basic tenets of evidentiary foundation, as well as authentication. They are prejudicial, and they should not be considered by the board, regardless of whether or not they are attached to the report.
But Mr. Bianco, I think I'm confused. I think the issue, the issue, and maybe in another proceeding, it becomes more relevant. But for the board, and the charge, I'm looking at the charging document, and the charging document stated that you violated the terms of your board-approved security plan by failing to contact Metropolitan Police Department or create an incident log after a violent incident occurred inside of the establishment for which the board may take proposed action. I don't think that I mean, an incident occurred. I'm not sure if the board is going to determine whether or not this is violent or not, but it's the case report by the agency. The investigator, as part of his investigation, is providing information that was received by him to say this is the basis of writing this case report. I'm going to overrule the objection. You are welcome to cross-examine the investigator, but I think at this juncture, based on the charging documents, I don't see the basis of your objection. So I'm going to overrule the objection, sir. And I said,
Well,
and that's based on what the charge is, and you'll have the opportunity during cross-examination to cross-examine this witness.
I get that, and I suppose my point is that these photos could have been taken anytime since years ago, up until the moment that this investigator received them somehow.
And you're
without laying
welcome.
that foundation, it's not proper to consider.
But you're welcome, and you are welcome on cross-examination to make those points, and I think the board will be in a better position to see what weight, if any, to give the documents, because maybe you could establish that that this was taken a year after the event. So I don't know. So I think at this juncture, again, I'm going to overrule the objection, and you'll have an opportunity to cross-examine the witness on his version of on your version of these photographs. But at least for my purpose, the charging documents is that it says that, and I don't believe that. And I'd asked that earlier. I do not believe that you're disputing that an incident did occur. I think what I'd heard earlier is that the incident did not occur inside of the establishment, and so because it did not occur inside of the establishment, the security plan violation did not occur. I think that's what I'd heard earlier.
That's part of our argument.
Right.
The other part being the severity of the incident didn't rise to the level requiring certain actions under the security plan, and this goes directly to that, and it's prejudicial and without foundation, which is the government's burden to establish the foundation of evidence that they want to admit. It's not admissible. It's not a hearsay objection, which would be laxed and likely admissible. It's a foundation objection.
But you're aware, the counsels, that the case report, by matter of law, is a matter of the record. The case report. So this is a case report. If this was a different piece of evidence that the government was trying to put in, I believe that your objection would be more relevant. But this is already a part of the of our record, because this is a case report. The investigator went out to do his investigation, and this is a photograph that was given to him by, I think, by the victim to support, to say what from the victim's perspective occur. And I don't believe that it's not been taken by me that the investigator is saying that this is factual or not. The investigator is just providing information that was given to him. And so I'm overruling the objection. This is in the case report, and the case report is already in as part of the board's documents that the board can rely on to make a determination. And as said, you will have an opportunity to cross-examine this witness on the documents that are in his case report. So I'm overruling the objection.
Thank you, Mr. Chair. At this point, Investigator Rose, I would like you to describe what you see in this photo, which has been marked as Exhibit 4.
This is a hand, partial forearm, and a red mark on the palm of the hand.
Okay, moving on to Exhibit 5. Could you describe what is contained in this photograph?
This is a photo of a knee injury, abrasion with some blood coming from it.
Moving on to exhibit number 6, could you describe what you see in this photograph?
Elbow, upper arm, with red spots.
And finally, exhibit 7.
Looks like a bruise on the forehead.
And based on, and you received these images directly from Mr. Scheit, correct?
Yes.
And he indicated that these images were taken immediately after the altercation, which took place on May 21st, 2023.
Objection, leading, argumentative.
I can rephrase.
Yes, go ahead, sir.
Did Mr. Scheit tell you when these photographs were taken?
No, he didn't tell me when.
Did he indicate why he was providing the photographs to you?
These are the injuries that were caused from the incident. That's what he indicated.
Thank you. Based on your review of these photographs and your review of the statement, do you believe that these injuries are consistent with the statement that was provided?
Yes.
Okay. I am now going to ask you a couple of questions about this version of the events. Does Mr. Scheit's version of the events describe a physical altercation between employees of Madam's Organ and a patron?
Yes.
Did that altercation originate inside the bar?
Yes.
If that altercation had taken place solely outside of the bar, would that have triggered the security plan obligations of the establishment?
Objection, calls for a legal opinion.
It does not call for a legal opinion. The obligations of the establishment under the security plan are clear regardless of where the incident took place, so long as it involved patrons and security members acting in their official capacity.
I don't think it says that at all, but what he's asking for is opinion testimony about a hypothetical situation that he claims doesn't exist.
The entire purpose of this is to determine that under any hypothetical interpretation of this, the obligations that the establishment has under its security plan are triggered by a violent confrontation between staff and patrons.
That's legal argument.
And I will make that legal argument in my conclusion, but I am determining whether the investigator in his investigative capacity believes that there was a violation that occurred which resulted in him needing to conduct an investigation into whether the establishment's security plan was violated.
So what's being asked is a hypothetical, not based on the facts that are admitted into evidence. That's what's being objected to.
All right. I'm going to overrule the objection and allow the witness to answer the question if he can.
Can you repeat the question, please?
Yes. An incident which initiated on solely an incident which only occurred on the sidewalk between security staff and a patron, which led to a violent altercation, would that trigger the obligations under the establishment security plan?
Yes, I mean, it's involving establishment employees and the individual.
Thank you. So, based on your evaluation of this statement, if this statement were true, would it have required the establishment to contact police and or EMS in regards or under its security plan?
Yes.
At this time, I'm going to move to what has been marked in the case report as Exhibit 11. Do you recognize this document?
Yes,
Is this the establishment security plan?
it is.
Could you read section A2 of the security plan?
Police and/or EMS are called for any emergency situation.
Do you believe that a physical altercation constitutes an emergency situation which requires calling police and/or EMS?
Yes.
Could you read section A1?
Security are trained to recognize and de-escalate conflict.
Do you believe that the statement made that an employee telling a patron that she was a whore who was sucking dicks in that bathroom is de-escalating conflict?
Objection. The government has time and again said this statement is not being offered to prove the truth of the matter assertive, and then is using the content to prove the truth of the matter assertive.
I'm going to sustain the objection. I'm going to sustain the objection.
I'll move on. Investigator Ruiz, did the establishment contact police and/or EMS in response to the May 21st, 2023 incident?
No.
Could you read section E of the security plan?
Managers are required to make incident reports for any issues that arrive inside the bar. If any matter is referred to MPD or ABRA, we refer to their incident report.
Okay. Now, did you, after receiving this statement, did you go to the establishment and speak to any manager of the establishment?
I went to the establishment to speak with the ABC manager that was working, yes.
And did that ABC manager provide you with an incident report related to the May 21st, 2023 incident?
Yeah, she provided me with statements from the security employees from their version of what occurred that morning.
And when were those statements made?
Only one statement was sent on June 10th via internal email, I guess.
Okay. Did the manager herself create that incident report? Or did she just forward the statement made by members?
Those were email statements that were forwarded to me. Well, one was an email statement, another one was a typed up statement that she forwarded to me.
And do you have experience in the past reviewing incident reports for establishments?
Yes.
What is the time period at which incident reports are generated?
Typically within either immediate to first 24 hours of the incident.
Is there any indication that there was an incident report that was generated immediately or within 24 hours of the incident?
I didn't see any indication.
And why are incident reports usually created immediately or within 24 hours of the incident?
To memorialize the facts that occurred that evening.
So, was there an immediate memorialization by the establishment of the facts that occurred on the evening of May 21st, 2023?
Not that I've seen, no.
The second sentence of Part E states that if any matter is referred to MPD or ABRA, we refer to their incident report. Can you explain why that provision would be included in a security plan?
Objection, speculation.
The investigator has testified that he has been dealing with security plans, that he's been dealing with investigations related to security plans and incident reports. This is a matter related to this establishment's security report. He's more than willing to and able to testify to why that language would be present.
This witness didn't write this report and had nothing to do with it other than reading it. If counsel wants to present argument as to its meaning, he can do that, but the investigator's opinion as to why something is or is not included is not relevant to these proceedings.
I'm going to sustain the objection.
Investigator Riz, do you know why the statements of June 10th, 2023 were created by the establishment?
They were created to be provided when the MPD detective was doing their investigation at the time.
So to your knowledge, those statements were provided after MPD reached out to the establishment related to this May 21st, 2023 incident?
That's correct.
Okay. Is it typical for an establishment to provide a incident report only after, or to generate an incident report rather, only after MPD has initiated its investigation?
I don't know if it's typical. Usually it's done right away.
Okay, thank you. So at this point, I would like to direct your attention to what's been marked as Exhibit 3. Could you identify what this is?
This is a statement from Giovanna Clark regarding the assault on May 21st, 2023 in Adams, Oregon.
And actually, just one last question on the previous statement by Mr. Scheit. Do you believe that that statement, if the facts contained in it were true, describes an assault?
Yes.
Okay. Onto this exhibit. Who is Giovanna Clark?
Giovanna Clark, it was a significant other of Mr. Scheit.
Okay. And could you read her statement?
Mr. Chair, I have the same objection to this statement. I understand the board has already ruled, but I will note my objection for the record and that I understand the matters being considered for reasons other than the truth of the matter asserted.
All right, so noted. Go ahead, Mr. Southlaw.
After ordering drinks, I went to the bathroom. I was talking with a woman and a bartender in the bathroom. The bartender was clearly drunk and complaining about the conditions of working at the bar. When I walked out, the bar was empty. I walked outside and saw Jake standing outside and looking at his phone. He told me that the bouncers wouldn't let him wait for me inside and said I was having sex with men in the bathroom. I walked to the entrance where one of those bouncers was standing. I was on the sidewalk in front of the bouncer, and Jake was silently standing behind me, also on the sidewalk. I asked the bouncer what he had said, and he leaned forward in my face and loudly yelled, quote unquote, I told him you're a whore who was sucking dicks in that bathroom. I responded, quote, why would you say that? And before he answered, another bouncer came from behind and grabbed Jake while he was standing on the sidewalk. Jake told the bouncer to get off of him until they both went down on the pavement. The bouncer was punching Jake and kicking him. Jake was holding the bouncer's legs to stop the kicking. Then the other bouncer, the one I was talking to, engaged in the altercation by hitting Jake. I was standing on the side begging the bouncers to stop and yelling for help. The bartenders from inside came out and everyone split up while Jake and I tried to calmly walk away without creating any more confrontation, but the bouncers continued to follow and insult us.
Thank you. Based on this depiction of the events, does this depiction describe a violent altercation which took place between a patron and members of the establishment security staff?
Yes.
Does this depiction also provide an account wherein security staff were making inflammatory comments to the victim.
Yes.
Does this statement indicate that that the incident originated inside the bar and continued onto the street?
Yes.
Based on your review of Giovanna Clark's account of how the events transpired, do you believe that this account, if true, triggered provisions of the establishment's security plan to contact MPD or EMS?
I'm gonna object again. The question is premised on whether the statement is true or not, which is not the purpose for which it can be considered. The government has not presented any admissible evidence as to the truth of the allegations, and that yet they're trying to rely on the truth of the allegations to make their case.
I am merely trying to present every statement that was provided to the investigator and point out that under each statement, regardless of whose interpretation you believe, they triggered the response of the establishment to abide by the procedures of its security plan. I will be doing the exact same thing for the statements of the employees.
I'm going to overrule the objection and allow the witness to continue testifying.
I'll repeat my question. Based on your review of this witness statement, do you believe that this statement describes a situation which would trigger the requirements of the establishment to abide by the provisions of its security plan to contact MPD or EMS because of an emergency situation?
Yes.
Do you believe that this incident, as described, triggers the provisions of the establishment security plan to immediately create an incident report as described in the, I'll strike the question. Do you believe that this interpretation of the events triggers the establishment's obligations under the security plan to create an incident report?
Yes.
Was MPD or EMS contacted by the establishment?
No.
Was there an incident report that was generated immediately after the incident occurred?
Objection. This line of questioning has been asked and answered.
Let's move on. That is correct. So I sustain the objection.
Okay. At this point, I will. Sorry. Does this document also describe individuals, employees making inflammatory statements to patrons?
Yes.
And the previous statement also described inflammatory statements to patrons, correct?
Yes.
Okay. I'm now going to move on to what has been marked as Government's Exhibit number 9. Could you describe what this, or no, not Government's Exhibit, but what has been described as Exhibit number 9 in the case report? Could you describe what this document is?
This was a statement provided by one of the security personnel, Walter Johnson.
And how do you know it's provided by Mr. Johnson?
Signed below.
Is the statement dated?
Walter Johnson. No.
And how did you receive this statement?
It was forwarded to me via email.
Who forwarded it to you?
The ABC manager.
And when did she forward it to you?
Don't know exact date, but it was within the investigation.
Did she forward it to you after you went to the establishment and spoke with her?
Yes.
Okay. And what was the date that you visited the establishment?
June 28th, 2023.
And this incident occurred on May 21st, 2023, correct?
Yes.
Could you read this statement?
Yes. It was closing time when we asked the gentleman to leave. His insisted that he wait on his wife, as we instructed him that he can wait on the front porch. As the wife returned to us arguing, she got into it with us as well, pointing her finger in my face. It then got to the front porch. We are still asking him to leave the property. He is still refusing to do so at this time. After closing, then he walks over to the outside patio where I told him it was closed, but then Aaron suggested that I go back inside, but then he started to go at it with Aaron making comments, so we all stood there arguing. Aaron said something he didn't like. Dude rushed him and grabbed Aaron in a football clinch, hold by the shirt. Aaron tried to move his hands, where the drunk dude tried to tie Aaron's legs up with his arms. Aaron lost his footing and fell in the process. I'm pulling dude's arms off of him. I guess he felt embarrassed or butt hurt because once he got to his feet, he felt like he was assaulted but hurt, but he started the whole thing. P.S. Walter Johnson.
Okay, I'm going to ask you some questions about this statement. Does this statement describe an incident which originated inside the bar?
Yes.
Does the statement describe an incident which depicts a violent altercation taking place?
Yes.
Does the statement describe an incident which involves the patron being hurt? I'll direct your attention to the last two lines.
I felt like he was assaulted but hurt.
Does the statement describe members of the establishment making inflammatory comments?
Describe that there were comments made. Doesn't describe exactly the comments that were made.
Does the statement said Aaron said something he didn't like, dude rushed him and grabbed Aaron in a football clinch? Did I read that correctly?
Yeah.
Based on your interpretation, or based on this statement, do you believe that it triggers the provisions under the establishment's security plan to contact police and or EMS for an emergency situation?
Yes.
Do you believe that this statement triggers the provisions in the establishment's security plan to generate an incident report?
Yes.
Okay. I'm now going to move to the last statement, which is been admitted as exhibit number 10 in the case report. Mr. Ruiz, could you describe what this document is?
So this is a Gmail email sent to me by the ABC manager regarding Aaron Payton's security officer's statement.
And who did Aaron Payton send this email
to? Miss Reynolds, the ABC manager.
And what is the date associated with the email?
Saturday, June 10th, 2023.
Can I have you read this depiction of the events?
The night of the incident, Walter told the gentleman to leave Madam's organ because it was closing time. He had an issue with Walter asking him to leave because he was looking for his girlfriend. He was informed that she would be coming out shortly, as would everyone. He walked out about a minute later. Walter told her that her boyfriend was being a jerk. She got upset and proceeded to argue with Walter on the property about what's said about her boyfriend while pointing her finger in Walter's face. The boyfriend, who was also on the property, was standing behind her in a threatening manner as if he may assault Walter. I stepped in between them and told the boyfriend to leave. He didn't listen. I then attempted to guide him off of the property, and it turned into a tussle. He grabbed my shirt, and was trying to push me back into Walter while repeatedly screaming, "Don't touch me." I stood my ground and walked him backwards off of the property. Still holding on to my shirt, he tripped and pulled me down on top of him as he was on the ground. He wrapped his arms around my legs and wouldn't let go. Walter and a bystander, whose name I don't know, had to pry his hands from around my legs so I could stand up. Once I stood up, he stood up. He screamed obscenities at us, and him and his girlfriend left.
Okay. Based on your review of this statement, does this statement describe an incident which originated inside the bar?
Yes.
Does this statement describe an incident which involved a violent physical altercation?
Yes.
Does this statement describe an incident which involves members of the bar making, or employees of the bar making inflammatory comments?
It was an indication that a comment was made. Yeah.
As a does the statement describe an assault?
Yes.
Do employees have an obligation, to cooperate with an ABCA or MPD investigation by providing true and accurate statements of events?
Yes.
Based on your receipt, or rather, what was the statement generated in regards to?
This statement was generated in response to be provided MPD's investigation.
And so this statement didn't exist prior to MPD reaching out with respect to that investigation. Did it?
That's my understanding. No.
Does this statement, is this statement consistent with the other three statements that in describing a physical altercation?
Yes.
Do you believe that, or sorry, if this account were correct, would this account trigger the obligations of the establishment under the security plan to contact MPD or EMS as a result of an emergency situation?
Yes.
Does this statement indicate an obligation for the establishment to generate an incident report for this situation?
Yes.
Okay. At this point, I'm going to direct your attention to the conversation that you had when you went to the establishment. Do you recall speaking with ABC manager Sarah Reynolds?
Yes.
And when did you speak with her?
June 28th, 2023.
And why did you speak with
her? Well, met with her to discuss the incident as well as to inspect and review their surveillance system.
And did you attempt to inspect and review their surveillance system?
Yes.
Were you able to do so successfully?
Yes.
were you able to view surveillance footage of this incident?
No, this incident was no longer available. The recorder was only holding a 10-day retention period.
Did the establishment provide a justification for why the information was no longer available?
I'm going to object. One, the issue of security cameras is not before the board. Two, Mr. Ruiz did not speak to the manager at the establishment until after 30 days had elapsed from the date of the incident. Testimony is not relevant, shouldn't be considered by the board.
I am merely having the investigator describe the methods that he conducted in the course of his investigation.
He's done that, and the length of time that their system held video for, or what he was told it did, isn't relevant to this case in any way, shape, or form.
All right, I'm going to sustain the objection. Let's move
on. Did you speak to Ms. Reynolds about the physical altercation which took place on May 21st, 2023?
Yes.
And what did you tell her about that altercation?
Basically, the apparent of a physical altercation that took place with security described the male physically grabbing and pulling down should be documented and surveillance footage recorded and saved going forward with any incidents like that.
And did you inform her that the establishment should have notified MPD?
Yes.
Why did you inform her of that?
Because they should have. I mean, a physical altercation took place. Physical altercation took place. Police should have been notified.
Would you say it's standard procedure for police to be notified whenever a physical altercation takes place?
Should be standard procedure. Again, I mean, the severity of the situation with the individual not leaving, the MTD should have been called to assist to remove them.
Okay. I also direct your attention to a little further down in the case report. Did the establishment document the incident when it happened as stated in their security plan?
No.
Why not?
Objection, speculation.
I don't know. My bad.
Well, let's move on. The witness stated that he can't answer the question. All right.
Was your case report states that the incident report dated June 10th, 2023 by Aaron Payton was provided after MPD Detective Allegria, inquired. Why did you include that information in your case report?
No, because it was dated June 10th and not immediately when not when the incident occurred. And to me, it was provided after MPD inquiry.
So last couple bit of questions. Under any interpretation of the events as provided by the 4 different witness statements, did each of those interpretations trigger the establishment's obligation to contact MPD or EMS following an emergency situation?
Objection, argumentative, leading, calls for a legal opinion.
It's not leading. This question is one that speaks to Investigator Ruiz's competency in terms of evaluating whether a violation has occurred.
It's testimony with a question mark at the end of it. It's absolutely leading. It's absolutely argumentative. This witness is here to put facts on the record. This is not a fact. It's an opinion.
The investigator would be more than permitted to say no to the question. It's not a leading question.
I'm going to overrule the objection. If the investigator can respond. If not, let's.
Can you repeat the question, please?
Does each account of the incident in question describe a situation which triggers the establishment's obligation under the security plan to contact MPD and EMS following an emergency situation?
Yes.
Does each account trigger the establishment's obligations under the security plan to generate an incident report following the establishment or in accordance with the establishment security plan?
Yes.
Does each account describe an incident which originated inside the bar and spilled onto the street?
Yes.
I have no further questions for this witness.
Mr. Bianco.
Yes, sir. Good afternoon, investigator.
Can you close the screen? Oh,
Yep.
Thank you.
Good afternoon, Mr. Bianco.
Okay, I have some questions about your report. I just went through it, sort of page by page, and that's how I want to try to focus the examination. So this incident here occurred on May 21st, 2023, but wasn't assigned to you until June 27th. Why is that?
It was assigned to another investigator previously who abruptly had to go out on leave, and then it was forwarded over to me.
Okay. And what instructions or guidance did you receive when the case was transferred to you?
To review and investigate the matter that occurred.
Was there anything more specific provided to you other than just review and investigate?
No.
And something that is not clear to me from your report is which statements you received from Investigator Dantzler and which statements you procured on your own. Could you clarify that, please?
So I obtained the two victim statements from Ms. Clark and Mr. Scheitz. That was forwarded to me by Ms. Dantzler through our supervisor, S.I. Brashears, from Ms. Dantzler. And Mr. Scheitz, I've had email communication with, which described the incident in his statement, and the employee statements from the security members was provided to me after my visit with Ms. Reynolds, discussing the incident. Yeah.
And that visit was on or about June the 27th, correct?
Yes, June 28th,
Okay.
2023, I believe.
Okay. And so do you know so I want to focus for a minute on the statements from Scheidt and Clark, which is the complaining witnesses. Those statements are not dated, and the report doesn't indicate when they were taken. Do you know when that occurred?
I do not.
Okay, but it was sometime prior to you being assigned the case.
Correct.
And do you know when in time, in relation to the incident, Investigator Dantzler started her investigation?
I do not.
And with respect to the Clark and Scheidt statements, they, aside from not being dated, they're not signed. Do you know who prepared them?
I do not.
And were there any notes in the transmission of the file from Investigator Dantzler to you about those statements?
No.
Now, do you know if there is any reason why, I'm sorry, strike that. What was the timeline of Investigator Dantzler going out for leave versus the case being assigned to you?
Objection relevance. I fail to see how
So
this has
this,
anything to do with the charge.
Yeah.
yeah, so this witness testified about how important it was to get information close in time to the incident. What I'm developing here is the timeline. So based on this, the investigator's own testimony, having an idea of the timeline as to when people were spoken with about what occurred in the incident is important. So that's the reason for the testimony I'm eliciting. It develops the timeline based on to establish the witness's recollection.
I'll overrule the objection.
So you need me to restate the question?
Yes, please.
Okay. So what was the timeline between when Investigator Dantzler went out for leave and when you were assigned the case?
I do not know.
Do you know when she went out for leave?
I don't know.
Do you know why Investigator Dantzler did not speak to the establishment being investigated at the same time as she spoke with the complaining witnesses?
I do not know.
When was the first time the agency contacted the establishment to inform them that there was an investigation into the May 21st incident?
Objection, again, on relevancy grounds, I fail to see how this has anything to do with the establishment's obligations under their security plan. ABCA's investigation is separate from their obligations under the security plan, and the only matter at issue here is their obligations under the security plan.
The questions go to the timeline, which the government went to great lengths over objection to develop. So I'm entitled to inquire into it since they put it on in their case in chief. It's within the scope of the testimony, and to the extent that the government, please let me finish my argument.
Gentlemen, all right.
So to the extent that it's relevant for the government, it's relevant for us to inquire into as well.
May I respond?
Yes, sir.
To the extent that the timeline matters for what the establishment was doing, not what ABCA was doing. The timeline for ABCA and its investigation has no bearing on whether the establishment was meeting its obligations under the security plan.
All right. I'll give him some leeway. So at this juncture, I'll overrule the objection. But Mr. Bianco, you know that as I read the charging statement, and so that's where I need us to go. All right, go ahead.
Very well. So do you know when the first time ABCA contacted the establishment to inform them that an investigation was being done into the May 21st, 2023 incident?
I do not.
Now, if we look at the police report that is attached to your report, and if I need to refresh your recollection, please let me know. I'll bring up the report. The MPD report talks about an apparent assault. Is that fair to say?
Yes.
Okay. And do you happen to know if any charges were filed in that case?
No.
You happen to know if any arrests were made in that case?
No.
Objection, relevance,
what their
MPD's
investigation
objection. Objection.
What?
MPD's investigation into how MPD conducted something with respect to this matter does not have any bearing on this establishment's obligation under their security plan.
We disagree. The government put on evidence that an assault occurred. They're using that assault as a basis to trigger obligations under our security plan. We are very much entitled to inquire into whether any assault ever took place.
But all right. I'm going to sustain the objection. It's irrelevant whether or not an assault occurred. I mean, at least as far, well,
Mr. Anderson, respectfully, this witness testified, quote, the severity of the situation I'm sorry, not all violent altercations should be reported. So the severity of this particular situation has bearing on whether or not their obligation to report to MPD was triggered. And if MPD does not consider or did not take action on what the government has couched as an assault, it is absolutely relevant to this case.
Mr. Chair,
all right,
MPD's, sorry.
all right. I'm going to sustain the objection because I think that when you talk about the timing, at least from my perspective, how MPD responds to whatever occurs in the establishment, that's not really relevant to us. We make an independent judgment about whatever investigation, whether or not an incident occur or whether or not that should be reported to us, and whether or not MPD decides that they're going to act on whatever decision, whatever occurred. So I'm going to sustain the objection. I don't see it's helpful. I don't see whether or not an arrest was made and whether or not MPD, how they responded. I don't think that's relevant to what decision that I need to make or this board needs to make on whether or not this establishment had an obligation to either call MPD or have an incident report.
Okay, very well, Mr. Chair. Thank you. Just like my exception noted. Moving on from there. You talked about the timing of the MPD report, that it was taken at 5:33 a.m. When was that in relation to the actual incident taking place?
That was the time and date of the report. I believe the time of the event taking place was roughly 3 a.m., 3:30 a.m.
And when you say the report, you're referring to
MPD's report.
MPD's report. So okay, very well. Moving on from there. Now, I want to talk about the photos that are marked as, I think, exhibits 3, 4, and 5 to your report. We had some discussion about that earlier. And do you know who took those photos?
I do not.
Okay. Do you know when they were taken?
I do not.
And you mentioned, I think, that they were sent to you. When were they sent to you by the complaining witness?
I don't recall. I would have to look that up.
Okay. And you have no idea whether or not they truly and accurately depict Scheidt's condition after the incident, do you?
No.
And it's true, isn't it, that they could have been taken at any time between before they were produced to the agency?
Correct.
I want to go to your page 5 of your report, and in page 5 of your report, you have a quote from a section of the security plan, and it's a standalone quote, and I think council had you read it into the record. It says, police and or EMS are called for any emergency situation, correct?
Correct.
Okay. So I think I do at this point need to bring up the report. So if you'll bear with me for a moment while I share my screen.
Mr. Oriana, please allow Mr. Bianco to share his screen.
Access has been granted.
Thank you.
Okay. So I have the security plan up on my screen, and council had you read section A2 into the record, and that's the section you quoted. Police and or EMS are called for any emergency situation, correct?
Correct.
Okay. Could you read the top portion of the paragraph there? So marked section A.
All security at Madams Oregon is trained for every location around the establishment by senior staff and management.
Okay. And then 1, 2, and 3 follow that, correct?
Correct.
Okay. And that subsection is what you used to draw your conclusion that the establishment is required to call the police in a quote unquote emergency situation, right?
Correct.
Okay. And did you ask the establishment at any point in your investigation about their training procedures?
I didn't.
And so as we sit here today, you don't know whether or not the establishment trained their security staff to call police and or EMS for any emergency situation.
Correct.
Okay. So you touched on this in your testimony as well, about this provision triggering an obligation of the establishment to call the police. You would agree, would you not, that your reading of this provision only requires the police to be called in an emergency situation, correct?
Correct.
Okay. And how do you how did you, in this case, make the determination that what occurred constituted an emergency?
From the physical altercation, describing the punching, the injuries, there's bleeding described, just the physical altercation in itself, I would determine to be an emergency.
Okay. So I want to walk through some of those things. All right. You said, I think first, the physical altercation and punching, right?
Correct.
Okay. And this notion of punching happening, where does that allegation come from in your report?
Punch. I thought I read it through Mr. Scheidt's statement.
Yeah. I'm sorry. I was just going to say I was going to make it easier. The only allegations of punching comes from Mr. Scheidt and his girlfriend's statements, correct?
Correct.
And they're, of course, not here to testify about that, correct?
Correct.
And I think the second piece of what you said, and please correct me if I'm wrong, you said the injuries and bleeding. Is that accurate recollection of what your testimony is?
Yes.
Okay. And your basis for that testimony is, again, the Scheidt statement and his girlfriend's statement, correct?
Correct.
and the photos.
Correct.
Okay. And the third thing you said was a little bit broader, so I want to drill down on this a bit. The third thing you said is the altercation itself. What about the altercation made it an emergency per se?
Anytime, I believe anytime individuals put hands on each other, or even a threatening matter, it can it becomes an emergency situation. But
Okay.
who knows what that could transpire from there, and why security should de-escalate it from that point.
Okay. So is there a particular policy or standard that sets forth that definition of an emergency?
No.
So where does that come from?
My knowledge, experience, violence, emergency.
So
What I know it to be through my experiences.
okay. So what you consider to be an emergency, if I'm to understand your testimony correctly, may be different from what another investigator would deem to be an emergency. Is that fair to say?
Objection. I don't believe that this investigator can speculate as to what every investigator considers to be an emergency and why his interpretation would be different from some other investigator.
So I'm asking him about his testimony.
We're asking him to
and,
speculate on the testimony of every other investigator.
I'm not asking him to speculate on the testimony of every other investigator. I'm asking him on cross-examination to talk about the possibilities of a differing standard within the agency in the absence of a firm policy.
I'm going to overrule the objection. The witness can answer the question if he can.
Do you need me to restate it, Investigator Ruiz?
No, I can't speak what other investigators would think, but I suppose there'd be a varying. I can't. I don't know. I can't say.
Okay. Going back to your report, I'm looking at what is page 5 of the report, and you should see it
Yes.
up on your screen. And the paragraph directly below the bold quote from the security plan says, in relevant part, after review of the statements, Investigator Ruiz did identify a situation that involved a physical altercation between a patron and a security employee, which resulted with both parties on the ground and a sign of bleeding injuries, which should have prompted the establishment to notify MPD. Correct?
Correct.
Okay. So how do you know that the bleeding injuries were apparent at the time this altercation took place?
I wouldn't know it at the time of the incident.
And the photos that are attached to your report, based on what I see, the only bleeding injury is from the complaining witness's knee, correct?
Correct.
And do you know how that witness was attired on the evening in question?
I don't know.
So you don't know whether he had shorts or long pants on?
No.
Okay. Now, on page 2 of the complaining witness's statement, he states that as soon as he got clear of the altercation, he walked away, right?
Yes.
And in your testimony, you indicated that the incident began inside of the establishment, correct?
Yeah.
And your basis for that is the supposed inappropriate comments made by one of the bar staff inside the establishment.
Yeah, with security, of course, closing the establishment, telling him to leave, and then the verbal back and forth happening, and then carrying out of the establishment.
Okay. So there's two parts to that, both of which I want to take in turn. One is telling him to leave the establishment. This was, is it your understanding that this was closing time and everyone was being asked to leave the establishment?
Is my understanding, yes.
Okay. So how would this particular person being asked to leave the establishment at the same time as everybody else be the beginning of an incident?
I think it was the it was the back and forth. From my understanding, with the comments being made, that led to what occurred outside.
So the beginning of the incident then is not necessarily everybody being asked to leave the premises, but rather the allegation that certain untoward remarks were made towards this particular patron, correct?
Correct.
And the only place that those remarks appear in your report are in the complaining witness's own statement. Is that correct?
Correct. I think I think I copy and pasted those statements into the report.
I think that is accurate, investigator. I think you did that as well. Now, are you aware of whether MPD has a standard as to when they should be called in the event of an assault?
No.
Objection relevance. I don't believe that the investigator is not a member of MPD and doesn't need to be testifying to MPD's standards for what it should be conducting its business. This is a matter before ABCA. MPD standards have no bearing on this case.
So I would say two things. One, he testified that he's not aware of any standards. And two, in the absence of any ABCA standards, it's absolutely relevant. Instead of having investigators on a case-by-case basis make it up out of whole cloth, the existence of a citywide standard from the policing agency is very much relevant.
All right, I'm gonna sustain the objection.
So the second piece of this allegation in this case is that the second conclusion that you draw in your report is that the establishment violated the security plan by failing to take an incident report, correct?
Correct.
Okay. And I could bring up we're talking about paragraph E. I think you may have read it into the record. But that particular provision specifically states that managers are required to make an incident report for any issues that occur inside the bar, right?
I'd have to look at it again. But
Okay, so we'll bring it up. Okay, so I have on my screen the security plan and directing
yes.
your attention to paragraph E of the security plan. And that indeed requires managers to make incident reports for issues that occur, or it says arrive, but occur inside of the bar, correct?
Yes.
Now, counsel directed your attention to one of the security person's statements that were taken in this case. And I'm going to scroll to it.
I think it might be further up.
Sorry about that. Okay, so it's exhibit number 9 specifically. It's the statement of Walter Johnson. And I think some of the testimony you gave was about Mr. Johnson's statement that when referring to the complaining witness, second to last line, I guess he felt embarrassed or butthurt because once he got to his feet, he felt like he was assaulted. Now, are you familiar with the term butthurt?
Yeah.
And does that refer to physical injury or hurt feelings?
Hurt feelings.
Okay. Now, in the actual body of your report, you make conclusions specifically on page 7 that the establishment violated its security plan because there was a physical altercation resulting in both parties on the ground and a sign of bleeding injuries. And then secondarily, in the next paragraph, the establishment did not document the incident when it happened as stated in their security plan, right?
Correct.
Now, nowhere in the report do you mention that the basis of your conclusion is that something occurred inside of the establishment, correct?
No.
So is there a reason why from the date that you submitted this report back in June of 2023 to today in March of 2024, why that fact has now been added to the allegations here?
I don't know.
Now, I believe your testimony, and please correct me if I'm wrong, is that in this case was that not all violent altercations need to be reported. Is that an accurate recollection?
Let me clarify. I was looking at the severity of the altercation contact, not that all altercations.
Okay, so
I guess distinguishing between an altercation that includes someone maybe being shoved and ending walking away, or an extended altercation to where people are grabbed, hit, becomes a little more violent in nature.
okay, so it's dependent on the how severe the altercation is.
Yes, that's how I looked at it.
Okay, and the recitation of the altercation as given by the personnel who work for the establishment was far less severe than the recitation by the complaining witness. Is that fair to say?
Yes, it appeared that way.
Okay. Okay, I don't have any further questions of this witness. Thank you.
Thank you, sir. Please close your screen. Any questions by any board members? Go ahead, Mr. Short.
Thank you, Mr. Chair. And thank you, Investigator Rules. I hope I won't be an hour like the last question you got. However, I would like to ask you, if you would, can someone put on the screen the incident report, please?
I can share my screen.
Thank you very much. And please go to the police report, the 251 that was put in.
Give me just a sec.
Thank you. All right, Investigator Ruiz, although you weren't given this initial investigation, what date is on the police 251, which we'll try to establish is it's a fact that when the MPD does reports, especially for Arbor, what does 251 stand for?
251, an incident report made from the police department.
Is that normally when a crime has occurred?
The crime incident that occurred, and with us being notified, it's usually an ABCA violation of some sort or some ABC incident or assault.
But the police report is dated the same date as the incident. Is that correct?
Correct.
That's a fact, correct?
Correct.
Okay. Now, also on that report, it gives the name of the victims. We say victims in this case because they're alleging they were assaulted. Do they give an address for the victim or the victim who was assaulted?
Yes.
What is that address?
It's a P.O. box. You want me to read the whole address?
Please do. I think it might be relevant to this case. It's a fact.
26 West Main Street, P.O. Box 893, Adamstown, PA 19501.
So would it be fair to say that someone who lives in Pennsylvania probably were glad to get out of Washington, D.C. after being assaulted and probably wasn't in a big hurry to come back?
Speculation, argumentative.
What's the question?
I'll rephrase it, Mr. Chairman.
Okay.
The persons on that night were from Pennsylvania who made the complaint to Arbor and to police. Is that correct?
Objection assumes facts not in evidence. Speculation, foundation.
That is
Again,
true, Mr.
I'll rephrase that. What is the address of the victim on the police report?
It's Pennsylvania address.
Why would someone give a Pennsylvania address if it's not relevant?
Objection, speculation.
I'll rephrase that. Is that the address that the person who is alleged to have been assaulted, is that their address?
I don't know. It looks like a mailing address.
Okay. Now, I'd also like to ask you, this establishment is a CT, is that correct? And give us what a CT is.
A tavern that's allowed to sell beer, wine, and spirits.
Okay. Now, this establishment, how long have they been there? Can you tell us when they first opened up?
I can't. I don't know off the top of my
You
head.
have no idea?
I know a long time.
Can you talk to us about the history on their arbor license? Their history on the arbor license.
I would have to refer to the history I provided in my report.
Can someone put that on the screen for us, please?
Is this the investigative history that you're referring to?
That is correct. Now, Mr. Ruiz, normally when a 251 is written, that means the police department was called. Is that correct?
Normally, yes.
How many times on the history of this establishment have they been called for assaults? According to their history.
Objection, relevance. There's no assault
Mr. Chair,
charges.
Mr. Chair, I would simply say, Mr. Chair, I would simply say it is a fact that the police were called because someone said they had been assaulted. That is a fact.
The fact is, these are all NFAs. They're not relevant to this particular.
Wait a minute, please, Mr. I understand you're trying to answer for me, but I'd like to ask the chairman if he would say, if our investigator can answer, how many times has MPD written 251s for this establishment? I think that's a fair question.
Same objection on relevance.
And Mr. Short, you ask a question, and Mr. Bianco, as the attorney representing the establishment, he is objected to the question that you asked because he doesn't believe that it's relevant to this to the issue at hand. And I'm in agreement with them, and so therefore that's not a question you should ask this witness, sir.
Okay. I would simply say this. Have you ever been to this establishment, investigator?
Yeah, I've been there.
Have you ever personally been there?
Yeah, I've been there.
Can you describe what you saw the nights or the times when you went there? What did you see when you went there? What did you observe?
An operating tavern usually has bands, usually security's on the front, doing pat downs. Normal operation of a nightlife establishment.
Okay. Now, recently, our District of Columbia government has started requiring places like CTs and nightclubs to have trained security. Is that correct? Recently.
Yeah, that's come up a lot recently, yes.
Why did the District of Columbia government decide to do that?
Objection, speculation.
No, there's a reason why they did that, sir. That's not speculating.
I think that this investigator, that's not a question that this investigator can answer, Mr. Short.
Okay, I just asked him if it's okay. Why, or did the district just change their laws for security? And security is a problem. Security has come up time and time again in this hearing. Is that correct, investigator?
I can only speculate on experiences. I don't know exact law changes or anything like that that have occurred.
Okay, well, let me rephrase that. The persons who were outside of this club who are accused of assaulting a person who had been in the club, as employees of the club, what they do, isn't the club have some responsibility, or does not the club have some responsibility, or the CT have some responsibility for their employees?
The establishment has some responsibility for the training, has a responsibility for the training of their staff and how to handle.
So if if that staff is inside and then have to go outside because of a person who has patronized them, does that give any responsibility to that establishment?
Yes.
So the security had the obligation, once they went outside and someone was assaulted, to call the police according to their security plan. Is that correct?
Objection, opinion, legal conclusion.
If the witness can, I'm going to overrule the objection. If the witness can answer it, if not, move on. Are you able to answer the question, Mr. Ruiz?
That's the understanding of the regulation.
So please state that answer again. To your knowledge about the regulation, did they have responsibility, the security?
Yes.
So them having responsibility, shouldn't they have called the police or even done some type of report?
Objection.
What's the nature of your objection, Mr.?
It's the same objection. The questions are calling for a legal conclusion. They're asking for an opinion on the ultimate issue that the board's to decide in this case. And the investigator is neither competent to testify about that, nor is his testimony on that issue relevant. It's the issue that the board is to decide based on facts. This is a fact witness, not someone who can draw legal conclusions or give opinion testimony.
Thank you, sir. Okay, thank you, sir. Did or did we not establish that the persons who are employed by this CT have responsibility when someone is inside of that club and they have to go outside of that club to respond to them? Yes or no?
Still part of the establishment, yes.
So they have responsibility.
Yes.
So wouldn't that responsibility also say that they should report it to MPD?
Yes.
Did they report it to MPD?
No.
So was that a violation of their security plan?
Objection. It's the same objection. I could restate it if the chair likes.
I think that the witness can answer this question because I believe I'm going to overrule the objection. If the witness can answer the question, he can, because I'm not sure. I believe that the witness did make some conclusion, I think, in this report.
See, my understanding of the security plan that they're required to call the police in this instance.
Okay. Now, Investigator Ruiz, it's very important to myself as a board member and hopefully the public that a fact came up that the young lady who was along with the gentleman who was assaulted was still in the female restroom when he was escorted out of the club. Is that correct?
I'm gonna object, as it's both a mischaracterization and any factual representations in the statements are not in the record.
Yes, I'll sustain the objection, Mr. Short. That's it. Let's move on.
Okay. Investigator Ruiz, is it a fact that when men escort women, they come with them and they leave with them? Is that a
Objection,
fact?
scope, speculation, competence.
That's not a question that Mr. Ruiz can answer, Mr.
Can't
Short.
answer
So let's move on.
Okay. So again, their history of this establishment has over 10 incidents. Does the history of an establishment have anything to do with the way it operates, Mr. Ruiz or Investigator Ruiz?
Same objection. I believe the chair has previously ruled on the relevance of the investigative history.
Mr. Ruiz, were there any assaults at all ever reported for this establishment?
Same objection.
Mr. Short, these are not questions that this witness can answer, sir.
Thank you, Mr. Chair. I'll be very brief. I know that I've been long-winded, but I see that we had other people who asked as many questions as I'm asking. I'm just trying to get so that I can make a proper opinion when I have to deliberate about this. I would really like to ask Investigator Ruiz again, if I could, if he has ever visited this establishment.
I have.
How many times?
I'd say at least a dozen times. I can't recall total.
Have you ever had to cite them for anything during those visits?
Objection,
I can't
relevance.
recall.
All right, let's. Do you have another question, Mr. Short?
Yes, I do, Mr. Chair. Thank you for allowing me to ask. In that neighborhood where this establishment is, how many or are there other CTs or taverns located in that neighborhood?
Yes.
Have you ever had to investigate any incidents at any of the other CTs in this neighborhood where this location is on 18th Street?
Yes.
What was the nature of those investigations?
Various investigations, occupancy, took to hospitals. It's very varied.
Would you say this is a very busy area?
Yes, on the weekends they're busy.
What day of the week was this incident on the 21st of May 21st, 2023? What day of the week or would you know that?
Not sure off the top of my head.
Investigator Ruiz, I thank you for a very thorough report for it, filling in for another investigator. And hopefully we will not be seeing this particular establishment again anytime soon. But you did a great job filling in, and thank you for the report you gave us. And thank you for your testimony today. That's all I have, Mr. Chair.
You're welcome, Mr. Short.
Thank you, Mr. Short. Any other questions by any other investigators? I'm sorry, any other board member?
No questions.
Thank you, Mr. Grant. Mr. Bianco, do you have any questions of the witness based on the questions that were asked by the board?
I do not, Mr. Anderson.
Thank you. Mr. Safka, any redirect?
Yes, briefly, I'd like to touch on a couple of matters. I'll share my screen again. Investigator Rez, during your cross-examination, you were asked about the security plan. Do you recall testifying about the security plan?
Yes.
And specifically, you were asked about Section A of the security plan, which is that all security Madams Organ is trained for every location around the establishment by senior staff and management. And then Section A2 says that police and/or EMS are called for any emergency situation. Do you recall testifying about this portion?
Yes.
As you read this security plan, is your understanding of it that the obligation is just for security to be trained on calling EMS in any emergency situation, or do they actually have to call EMS in an emergency situation?
That they actually have to, that they're trained to call.
And so if they did not call, they would be violating their training, correct?
Correct.
And would that be a violation of their security plan?
Objection calls for a legal conclusion, opinion testimony on the ultimate issue for the board to decide.
I believe that this witness has testified to this type of question before. I believe he can testify to it again.
I'm going to overrule the objection and allow him to answer if he can.
Yes, it'd be a violation. That's the question, right? I'm sorry.
I'd also, while we're talking about the security plan, do you remember the testifying about focusing on the section that says managers are required to make incident reports for any issues that arrive inside the bar? Do you remember testifying about that?
Yes.
And you recall opposing counsel emphasize that it is incidents that just arise inside the bar, not incidents that arise outside the bar. Do you recall that?
Yes.
So according to opposing counsel's interpretation of that, if an incident occurs regardless of the severity of the incident between an employee and a patron, but that incident occurs outside, then according to that interpretation, that would not trigger any obligation in the establishment to create an incident report.
Objection,
Is that right?
characterization, argument.
I want the witness to testify to manners that he just testified to with respect to what the security report says about whether there is an obligation that is triggered by an incident that originates inside the bar.
I'm going to overrule the objection and allow the witness to answer the question if he can.
Can you ask the question again, please?
Yeah. So according to the interpretation of the incident report, where the establishment only has to make a report for incident that arrives inside the bar, if an incident occurs between a patron and a member of security that takes place entirely outside the bar, according to that interpretation, then the establishment wouldn't have to make an incident report regardless of the severity of the incident, correct?
Correct.
Do you believe that that is a reasonable interpretation of what a security plan does?
Objection, this witness's opinion on reasonableness of a security plan is not relevant to these proceedings in any way.
This witness has testified that he's dealt with security plans and incident reports on dozens of occasions in the past. I believe he is more than able to testify as to a reasonable interpretation of a security plan.
That is not the role of the investigator. So I'm going to sustain. I'm going to sustain the objection, and I think in the word reasonableness. I mean, it's either yeah. So I'm going to sustain the objection on how the question is characterized.
Okay. I'll move on. So, investigator Rose, during your testimony on cross-examination, you clarified some of your statements about what types of incidents are ones that trigger the requirement to, or rather, or what constitute an emergency situation. Do you remember testifying about sort of what levels of interaction between patrons and staff constitute an emergency situation?
Yes, I recall.
And during your testimony, you said that something like shoving a patron would not rise to the level of an emergency situation, but grabbing them in a prolonged conflict would rise to the level of an emergency situation. Do you recall giving that testimony?
I do.
Okay, I'm going to direct your attention to exhibit number 9, which is the statement provided by Walter Johnson, the member of the establishment's security. In this statement, does this statement describe a physical altercation that involves grabbing another individual?
Yes.
And so based on your understanding, does this statement from the establishment trigger the obligation to contact MPD or EMS in response to an emergency situation?
Same objection. I realize the board's ruled on this, but I just want to note it. Thank you.
And that is correct. So I'm overruling the objection, so the witness can answer the question if he can.
Yes.
Okay, thank you. I'm actually going to go back down to the security plan just for a second and focus a little bit more on section A2, which states police and/or EMS are called for any emergency situation. Does the security plan define what an emergency situation is?
No.
Is there any provision that you are aware of that defines what a quote unquote emergency situation is?
Not that I'm aware of.
So is there any authority that anyone could point to that definitively indicates what an emergency situation would be?
No.
Okay. I have no further questions for this witness. Actually, sorry, I have no further questions.
All right, thank you. Thank you, Mr. Ruiz, for your testimony. You're free to go.
Thank you, sir.
Close your screen, please.
Yes.
Does the government rest?
The government does rest.
All right, thank you. All right, we're going to take a break, but before taking a break, I just want to know scheduling. How many witnesses do you plan to call, Mr. Bianco? Or does the government wish to, or better yet, are you going to call any witnesses?
Yes. I intend, based on the presentation of the case, to call 3 witnesses, as I think I initially indicated. And there's one other thing I think that bears a brief discussion is Mr. Southcott indicated at the outset of his case, he may want to make a dispositive motion. And I indicated that I may want to as well. I think we both do. And perhaps we should decide how that best be presented to the board in terms of scheduling out the rest of this hearing today.
I'll clarify. At no point did I say that I wanted to make a dispositive motion, and did not then and do not now.
Okay, that answers that. I thought that you, Mr. Bianco, had made and alluded to the fact that you might request a direct verdict.
I do wish to do that. So again, from a scheduling standpoint, I think we can maybe discuss quickly how we want to handle that.
So why don't you make your motion then, sir?
Would we be able to take the break first so I could gather my thoughts and make it more concise? That may be appealing to the board.
It's 4:00. We'll take a 15-minute break.
Thank you for having mercy, Mr. Anderson. I appreciate it.
I did tell you I was about to take a break. I wanted to take the break from 3:30, but it was not appropriate to break at that juncture. So anyway, we're off the record until 4:15. Okay, thanks.
Thank you very much.
All right. We're back on the record. Okay, we're back on the record. Do you have a motion you wish to make, Mr. Bianco?
Yes, I do, Mr. Chair. I would like to make a motion. I suppose it's in the style of a motion for directed verdict. We could also call it a motion to dismiss. I don't know exactly what to label it, but I will have a brief argument on it and we can go from there. We move that this charge against my client be dismissed. And the basis for our motion is that the government has the burden to prove all of the elements of the charge. Here, the establishment is accused of violating its security plan in two ways. Number one, by failing to report a quote unquote emergency situation to MPD. And number two, by failing to take down an incident report. First, there is no provision in the security plan requiring that the establishment call MPD after an emergency incident. The government cherry picks a subpart of an overarching paragraph that talks about how security staff is to be trained. Specifically, Section A talks about training requirements of security staff. And subpart 2 underneath training indicates that the security staff should be trained to call MPD in the event of a quote unquote emergency situation. Per the testimony of the government's only witness and the sole exhibit presented by the government, there was no inquiry, let alone finding, with respect to the establishment failing to properly train their staff. Since they have failed to put on any evidence that the plain language of that particular provision has been violated, the government has failed to meet its burden on that point following their case in chief. Second, my client is accused of failing to take down an incident report. And now we're dealing with paragraph E of the security plan. And again, our argument is one of the plain language of the security agreement, which we think is how the board has to read this. What that provision requires is the making of an incident report for situations that occur inside the establishment. It's a bright line test. There's nothing in the report, in the narrative portion of the report, or in the portion prepared by the investigator, that indicates that there was anything that occurred inside of the establishment. And we need only look to his conclusions on page 7, where he doesn't mention any nasty comments or rudeness with respect to that being the basis for something happening inside of the establishment. This is something new that the government raised today, months and months after the report was filed. And I think the more important piece of the argument with respect to the incident report is that there is no evidence on the record that anybody said anything to this person in any way inappropriate while inside of the establishment. The government has some tortured analysis of how the incident began inside the establishment based on the statement, the only statement of the complaining witness, which is not admitted as evidence for the purpose of any of the facts in it. There are no facts indicating anything happened inside. And that bright line test is why the government's case fails on the second point. The last thing I would note with respect to our motion is that security plans are, of course, submitted and approved by the board. And I think your attorney does an excellent job of conducting very thorough and detailed reviews, often kicks them back to attorneys and establishments for revisions. And that didn't happen here. What we're dealing with is a board-approved security plan that was followed to its letter in this particular situation. Moving on from the motion, we do have an additional argument that is not part of the motion that we will present facts on, and that will be whether or not the situation that occurred constitutes a quote-unquote emergency. But that's not part of the motion. I think that requires development of a factual record to succeed on that defense. Thank you.
Thank you. Mr. Southcott, do you wish to respond?
I have several responses. So addressing Mr. Bianco's arguments in turn rests on a very tortured understanding of what a security plan is, how one operates, and how one should operate under this instance. According to him, the only obligation under the security plan was that the individuals had to be trained to call police and or EMS for any emergency situation. Therefore, regardless of the severity of any situation, they would not have violated the provisions of the security plan by failing to contact police or EMS, so long as they had been trained to do so. Clearly, the purpose of training is for it to be put into practice. It is a tortured understanding of how that security plan operates when, if you want to use the plain language, trying to shove a clear requirement that police and or EMS are called for any emergency situation under a subheading regarding training that then seems to, per the establishment, provide no further obligation. We can tell that this is tortured because this is contrary to the testimony that was given by the investigator as to what he believed the establishment's obligations were under the security plan. He testified again and again and again that according to the security plan, that the personnel of the establishment have an obligation to contact police and or EMS for emergency situations the way that it says in the security plan. To say that the security plan does nothing more than lay out a training regimen and then say that failure to abide by that training regimen does not constitute a violation of the security plan is a somewhat preposterous argument that I argue that the board should not adopt. With respect to the provision that managers are required to make an incident report for any issues that arrive inside the bar, we have a similarly tortured logic, where the only justification for them is that there is apparently a clear bright line test where something either occurs inside the bar or outside the bar. Now, despite the evidence that we heard from the testimony of Investigator Ruiz repeatedly referring to incidents that originated inside the bar with comments that were made, which were then directed out, this is again contrary to the argument that Counsel Bianco just made, that those comments were made outside. We have testimony on the record, again, noting that everything in the case report, including the statements of the witness, is in the record. We have testimony from a witness in the record indicating that those comments that were first made, saying that Miss Clark was in the bathroom sucking dicks, those comments were made, according to his statement, while he was standing outside of the bathroom waiting for her inside the establishment. So his argument that everything occurred outside of the establishment is not true, even under its own terms. But even But we take issue with the fact that it says that, nope, there is only an obligation to create an incident report for issues that arrive inside the bar. As a quick side note, Bianca, the opposing counsel, makes hay of the great detail to which these plans are reviewed and approved. We have a clear typo in this relevant provision, which says that for any issues that arrive inside the bar, it very clearly should be arise, not arrive. Given that, it's hard to say that this was drafted with the exacting precision that he seems to think that it implies. Even were that the case, that it would only trigger an obligation for something that occurred inside the bar and not outside of it, this is also facially ridiculous, because that again has nothing to do with severity and is at odds with the way that the rest of the portion of the security plan is written. Note that managers are required to make incident reports for any issues, regardless of the level of severity. Any issue is required, a manager is required to make a security issue. But their understanding is that, well, so long as it is inside the bar, the second that you are a blade of grass outside of the establishment, regardless of whether that incident took place inside the establishment, whether that was between patrons of the establishment and members of the establishment, and regardless of the severity of that incident, then there is absolutely no obligation under the security plan for the establishment to make an incident report, regardless of the severity of what happened out there. So per them, an individual who works security could walk outside, produce a gun, shoot a bystander, and then there is no obligation for them to even make an incident report, despite the fact that if a patron were to lightly push a member of the establishment's security inside the bar, that does trigger their obligation to make an incident report for any issue that occurs inside the bar. That's also a nonsensical interpretation of the security plan, and it's not what the security plan requires. The security plan requires that incident reports be made for incidents that arise inside the bar. This incident arose inside the bar. Had the patron not been, and this is undisputed across all accounts, had the patron not been inside the bar, there would not have been a physical altercation between the patron and bar staff. It is impossible for them to escape this just by saying, because he was outside of it, we think, according to some interpretations of this, that does not trigger the requirements of the reporting requirements that exist under the security plan. For this reasons, the district believes that it is more than amply met its burden, and it's wholly inappropriate for the board to dismiss the case or to issue a directed verdict in favor of the establishment.
Thank you, sir. All right, the board is not going to make a determination. The board will reserve a ruling on whether or not a directed verdict will be issued or to dismiss the matter at this juncture. It's more important for us to preserve the record. When the board issues its ultimate decision, the board will make a ruling at that time on your motion. Okay, so that's the board, that's the decision. So I'm deferring making a decision at this juncture. What the board, however, will do at this juncture, you have informed us, Mr. Bianca, that you have 3 witnesses. The board is going to end this hearing at this juncture. We're going to end the hearing today and have the parties, the board will provide some dates to resume this hearing, and to resume the hearing in the sense that you will present, you'll call your witnesses, and it's late in the day. The board has another full day of hearings tomorrow, and I think it's appropriate for us to end our day on this note today.
Sure.
Okay.
Thank you, members of the board.
Thank you.
Thank you. So I'm not going to close. So I'm not closing the record. I'm not going to read the ruling because the board will not be discussing this case. So, but let me close the record. I have to close the record. I have to close the record for the day, but I'm not closing this case because we're making no decision on this case until we reconvene to hear the respondent present its case, okay? All right, as chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, in accordance with Title III, Chapter 405, Office of Open Government, I move that the ABC Board hold a closed meeting on March 21st for the purpose of discussing and hearing reports concerning ongoing or planned investigations of alleged criminal or civil misconduct or violations of law or regulations, and seeking legal advice from our legal counsel on the board's investigative agenda, legal agenda, and licensing agenda for March 21st, as published in DC Register on March 15. Is there a second?
Short, I second.
I will take a roll call vote on the motion before us now. It's been properly second. Mr. Short.
Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, as it appears that the motion has passed, I hereby give notice that the ABC Board will hold this closed meeting pursuant to the Open Meetings Act. Notice will also be posted on the ABC Board Hearing Room Bulletin Board, placed on electronic calendar and ABCA's website, and published in the DC Register in as timely a manner as practical. Thank you for your presentation today. Our legal office will get back to the parties with a date to reconvene this hearing. Thank you very much. Have a great day. I ask all board members to return to executive session for a brief meeting. All right. Thank you. Have a great day.
Thank you, Mr. Chair.
All right. Bye-bye.